from these one can make out that those who were there prior to 1980, although there cannot be a right created on the reserve forest in view of the 1980 Act. In the case of the petitioners, as I could see, even the Tongia, they were just asked to, if they were tell the Tongia, they were only asked to reside there. If you see those rules which have been made, there were also the concept of issuance of patta. That patta has also not been issued to the persons concerned. Rule 4 of those rules say that, Rule 5, it says at most a family can be given 35 acres of land. But this is also to be supplemented by way of contract. But there's nothing, no patta, nothing to the effect. So the question of creation of a right in a reserve forest does not arise. And these rules were all made, all these amendments which have been made also were prior to the 1947, prior to the independence. Thereupon, one has also to take note of that if you see the Indian Forest Act of 1865, 1878, 1927, all these are for the purpose of use of the forest produced by the state. Yeah. Therefore, their basic concept is they are trying to reserve it. Therefore, they use the word reserve. Why they use the word is reserve? So that they are reserving it for their benefit. Now, another very interesting aspect is the Indian Forest Act, Assam was annexed in the year 1826. After that, the 1878 Indian Forest Act came in. The moment the Indian Forest Act came in, all over India, the British issued notifications. Therefore, you find in the case of not Nambur or the Doyong, but the case of Borapati, as well as another forest which was there, these are made under 1878 Act. And these acts, these are made under Section 34. 34 means you don't require even the requirement of any inquiry. To be just, so therefore it will be not done. This is not done in terms of Section 4, 3, 4, 5, or 6 of the 1878. 1878. Now, what happened in the meantime, once it is being enforced out there, you have to also understand at that point of time the Assam was mostly inhabited by tribals or indigenous people, we may say. So they had a huge problem because they had the fishing rights, the hunting rights, all these rights were there. And the biggest problem was the June cultivation. The 1878 Act did not say anything as to how to tackle with June cultivation or those unclassed forests. So therefore, in the 1878 Act, you have three types of forests. One is forest village, one is what we call the reserve forest, and one is protected forest. These are the three forests which were there. But you did not have the concept of an unclassed forest. So therefore, a resolution was made. And pursuant to those two resolutions which were made before the British Parliament, the Governor General in Council have passed those. And one also has to understand that British India never considered Assam but have ruled Assam as a part of the British India. So therefore, it was done as a chief commissionership. Now, when it was a chief commissionership, so therefore, what had happened? The chief commissionership did not have the power to make an act. Therefore, you have regulations. There are some land and revenue regulation, there are some forest regulations, because these are being made by the chief commissioners. Now, if we just digress from here, this reminds me about those matters pertaining to the Joydol, Sivodol and all. I was just thinking, why did 1901 Act, there was a one act pertaining to ancient monuments and all. Why these were published in the Assam Gazette? Now I get the reason that it has been published in the Assam Gazette because it could not have been published in the Gazette of India. It had to be published in the, because it was ruled as the chief commissioner. Now, 1878 Act, these are happened. Then comes, you have the 1891 Act. Now, once this 1891 Act came in, there was a big problem taking into account that how to rule this, because the indigenous people were not happy with these acts. So therefore, you have this, they call it, there's a specific name of it. So wait, name is General Rules and the Regulations having the force of law. And then another is rules having the force of law and executive orders relating to force. Now, out there, general rules under the regulation having the force of law refers to the rules for establishment and control of the forest villages. Now you come to this chapter 3, how it is to be done. So it categorically mentions how it is to be done. Therefore, you have those rules that Bhuya was placing. Those rules which have been made as made under section 72, regulation 72 and all. Now, you also have a rule for eviction. These rules are made under 72C. So those persons whose rights have not been created in terms with the 1930 rules, they can be evicted. So it is not based upon an executive order or absolutely under the faith of the executive. These rules have been made at that point of time. It also mentions, these rules also mention how the maps are to be prepared. The maps are to be prepared, drawing it as per what you have done from the Survey of India maps. So from there it is to be drawn up. It's to 1:1 lakh square inch. 1 inch is equals to 1 lakh square. Yeah, and this is the ratio in which it is to be made. That's the scale. That is the scale. Scale. So that is how it is to be done. Anyway, those will be part of my judgment they are putting it. But only thing is, I need that aspect one. And secondly, what is to be done? Because prior to 1980, if these people are there, they cannot be, because you have the another judgment of the Supreme Court in the case of Africa 1980. Anupama mineral. Anupama mineral is the case. And another is the nature lake. Nature lake, this is a very interesting judgment. The nature lake is a 2009 nature lovers movement. Correct. Nature lovers movement is the case where they say that section 2 as a non-obstinate clause. They don't have a right, although the central government may. Central government has the power to say that, okay, you can reserve these for any other purpose. But if it is not initiated by the state government, the question of even the central government cannot exercise that power. It's an important judgment on that national level. But one thing from these judgments one can gather that no rights can be created upon the petitioners or any person in a reserve forest after 1980. If they were allowed to settle at that point of time, you may the revenue department may take a decision in respect to their rehabilitation in some other place, but not in the reserve. Reserve forest has to be clear.
There is a series of judgments passed by PM Godavari has categorically said that there should be a committee should be constituted statewide for the demarcation of the boundaries of the reserve forest areas. Now in our state, whether that committee is constituted or not, that is a weird thing.
No, but now the thing is like this. TN Godavari is there. There's no problem with that. But in view of the Abdul Khalid,
Yes, that committee.
the court has already committed that under such circumstances, that issue we can't digress or when you go into that because this is already there. And in pursuance to that, they have done their exercise.
Yes.
Because we are whatever may be.
Yes, sir.
Some exercise has been done for proper identification.
Yes, sir.
And we have to give credit to that if this identification remains for future, not for this matter itself, for future, everything remains. So therefore, if these geographical coordinates are being brought in, and that becomes a part of it, it will be helpful. In fact, it is only in the judgment of the Supreme Court in PN Godavari in 1997, where the Assam Forest Regulation, as well as the Indian Forest Act, 1927, were assimilated for the first time. Earlier, prior to that, Assam Forest Regulation had been considered separate. It is only there it says that what in whatever name you call, a forest is a forest.
If we see the timeline also, forest was earlier in the state list. By 72nd Amendment, 1977, it was brought to the concurrence. Then, my lord, the Forest Conservation Act came in 1980. But prior to that, my lord, state had the absolute authority. That has been, firstly, it was brought to the concurrent list, then Forest Conservation Act came. The
No,
state on its own cannot do
This
it.
aspect I know, because I have written it in the judgment of state of Gujarat. I read that. I put it that there was a necessity why what had to be done because the forests were in a very bad shape.
Yes, sir.
And under such circumstances, it had to be done something for which an amendment was made to the constitution, thereby bringing that particular entry into the concurrent list.
Yes.
And this empowered them to make that forest conservation.
So now all laws of state will be subordinate to the Forest Conservation Act. For example, my lord, Section 28 of the Assam Forest Regulation says, the state government may by notification in the official gazette direct that from a date to be fixed by such notification, any forest or any portion thereof reserved under this regulation shall cease to be reserved. So this provision has become redundant. It has become redundant.
Forget about that. The 1930 rules, although may say many things, but after the 1980 Act, there cannot be a creation of any right. As no rights have been created. Now these rules were being made because these were made, had to be made under compulsion at that point of time. You have to also understand, that is why I was saying 1878, 1891, the regulation and the act came in. There was a huge hue and cry as regards June cultivation, as regards rights of fishing, hunting, and all. Because at that point of time, it was going on. How to tackle it? This is why in 1897, the rules were due. I was saying, the general rules and one is the special rules for this, for settlement and all. And then they were given for Juning cultivation, they were privilege was given, but not a right. So this is how it changed. But then also nobody had a right. Now also, if you see the forest policy, as on date also, this is being said that it is again a problem. June cultivation still continues out there in certain areas, and because of that, the forest officials are having a problem. So something is being done. This is one of the aims of the forest. So anyway, so therefore, you being the additional advocate general, you have to also say as to how the government is going to take care of those people as regards some rights who have prior to 1980, taking into account that the Assam forest policy is not the forest department. It is the forest policy of the state.
Yes. In that aspect, I will put it on affidavit, because there are judgments of
But this is
how to rehabilitate them.
if some rights are there, so that right need to be also looked into. It with some competent authority. have allowed these people to remain prior to 1980, then also they cannot be allowed as no real right is created, because the right will only be created when a patta is issued. No patta has been issued. So there is no right creation of this. So they cannot remain in the reserve forest, but they can be accommodated somewhere else.
For that matter, the state forest policy, land policy 2019, consistently we are taking that plea that anybody getting evicted can apply for the state land policy under 2019.
So something has to be
They're
brought
all
on
put it on
record to that. So those people have to be looked into in this. But other people, no. Just throw them.
Well, may I indicate one thing, madam? In item number,
Why not some rehabilitation for them
that I
also?
will put it on
They
application.
are also, they are also being human, some rehabilitation.
State has limited resources.
You have to also understand, Mr. Bhuya, limited resources. I can't pass a
No,
mandamus out here to that effect, because the moment I do it, it will be a floodgate.
There are two cases filed, madam, which were disposed of regarding rehabilitation, which were disposed of, indicating that it is a state prerogative, state will look into it regarding rehabilitation. For that-
Obviously.
for
The
that,
state
which
has to, no, but it is also the policy of the state.
Land policy 2019 will be applicable.
Understood, but you have not overridden the Assam Forest Policy of 2004. You will still find it in your website.
Yes. Well, item number 15, 16 and 17, my lord. 15, 16, my lord. 17, we have not filed it. That I will file.
You file the affidavit, then we take it up on another day. Because you file it, then only it will be there. Mr. Bhuya, as regards those maps, it appears to be proper, although I'm not going to say it, because your question as regards 65 being not good water, because this court, although it's a court, but in fact, it cannot be a court for the purpose of section 65B.
Well, I have, later on, I have talked about that submission.
That would be a case if it was, this thing is being produced before the civil court,
That is so too.
or if it is produced before the criminal court. In fact, this is not a court, therefore you don't have the Limitation Act as an apply us.
Because that is why I have an affidavit also.
And it has been given to the effect. So that 65B will not have good water out here. And particularly presently, you see 65B was, those judgments were in respect to 65B. Now the BSA gives a departure from that. Now, earlier it was 63 and 65, the primary and the secondary evidence. Now it is 61 and 63. Now with 61, even a file which is there in a computer, a temporary file in a computer would be taken as a primary evidence, not a secondary.
If I may indicate, there are two other repetitions, filed together, not listed. Pertaining to Jamuna Modonga, there are two other repetitions. That may also be listed as listed. Yes, there will be total 12 cases now.
So one affidavit of Jamuna Mudunga would do.
And
Because
one-
their issue is out there, that Jamuna Mudunga, the issue is, yes, Tongia,
Tonga and other settlers are also there.
who is outside or something.
In fact, in Damuna Modonga, we have found that some patras were also issued. Those documents we have of late not be accessed.
No, that will be, therefore I'll leave it to them. But there cannot be a issuance of patta post 80.
No, my lord, it is 1950s, 60s like that.
If those are there, then they will take a consideration for that. If a patta is being issued out there, the patta, again, the another interesting is the patta is issued for 30 years or 20 years or 1 year. With these, after 1980, there cannot be an extension. This is what has been held by the Supreme Court in all these judgments. There cannot be an extension of anything. By statutorily, this is barred. If they can't issue a patta, means they cannot renew a patta. Then if they cannot renew a patta, even issuance of a patta prior to 1980 is gone. Unless you challenge section 2.
Those two cases are WPC 1616 and 1633, 26.
Here, the living council, senior counsel assisted by so and so, as well as the other counsel who appears on behalf of the petitions in the present batch. Also heard Mr. Ian Sami, the drafted by so appearing on behalf of the Forest Department. This court had reserved the judgment by the 2026. However, while drafting the judgment, this court found that out of the 5 reserve forests, that is Doyong Reserve Forest, Number South Reserve Forest, Warapani Reserve Forest, Lutumari Reserve Forest, and Jamuna Mutunga Reserve Forest. The affidavits have been filed only in respect to affidavit have not been filed in the as regards the Jamuna Mutunga Reserve Forest by the Forest Department. It is the opinion of this court that without the affidavit filed in the case of Jamuna Mutunga's reserve forest, it would be difficult on the part of this court to adjudicate the matter. Mr. P. N. Goswami, the learned senior counsel, as well as the standing counsel of the Forest Department.
Additional, I'm appearing at the additional.
Appearing as well as the additional Advocate General, appearing on behalf of the government of Assam, submits that the said affidavit will be filed within 2 days. Can we file it by 8? By 8/5/2026. During this court also finds it very relevant to take note of another aspect of the matter which was not brought to the notice during the course of the hearing. It's in relation to the Assam Forest Policy 2004. And more particularly, to clauses 4.3.1 and clause 4.3.1.1. And more particularly, to clause 4.3.1, which relates to encroachment, and as to how the state government is required to take steps in respect to those identified pre-1980 encroachers who have been allowed to enter the forest area by any competent authority. This would request both the councils appearing on behalf of the parties to address on the said clause, as the same would have appearing, taking into account that some of the petitioners claim that they have been residing. They have entered the forest area on the basis of authorization by the competent authority, and those were prior to 1980. When can we have it? Monday or Tuesday. List the matter again on 12/5/2026, 2 p.m. or 10:30? 2 p.m. 2 p.m. 2 p.m. for further hearing. The interim orders passed earlier shall continue with the next day.
Now the other 2 cases also.
Mr. P. N. Goswami, the learned senior counsel, further submits that in addition to the present batch, there are 2 other petitions wherein the issues are similar. The said petitions are the petition number
1616 of 26, 1633 of 2002. Pertains to Jamuna.
The said petitions be also tagged by the registry along with the present batch and listed on 12/5/2026.
Deeply. I'm glad. I love.
You see this nature lover movement. That is a very important as to how the forest department is to deal. how there can even the creation of a right is there, because this is the aspect which both of you need to examine. Even if there is a creation of a right prior to that, and it requires an extension, it cannot be granted an extension. Because then, the moment you grant an extension, it has to be done with the concurrence of the Sub. That is the
Lovely.
What is this?
So they filed, the ONGC respondent number 4 has filed an affidavit yesterday. It's basically it's shifted the onus on APHCL. APHCL, I think, is represented by my
I will kill it for this one. What are you asking for?
because I am asking for my balance contractual amount of rupees 2.86 crore.
Why are you here? Or without interest?
Without interest, in fact, because I am told, my instruction is that they are trying to settle the matter with the APHCL outside. But I think in this proceeding, the APHCL affidavit needs to come on record.
Who's the affidavit?
The APHC, the phone number 1,
APDC.
yes, Assam Police
APHC.
Housing Corporation.
Assam,
Police Housing Corporation Limited.
you have to pay.
I have to pay, but,
I appear on behalf of ONGC, respondent number 4.
You paid it to them.
Yesterday, I have already filed the affidavit also. So I may be allowed to, though affidavit has been filed by ONGC, some other instruction is also required. I have seen their contention. So I may be allowed at least 10 days time to file additional affidavit.
So why didn't you file it at the first point? Why you are asking me? Or you keep on filing it? We allow you ONGC to do so with the cost of it. You don't file additional affidavit. You file it yesterday and now you, without nobody saying anything, now you come up that you want to file another addition.
No, not say. Not say.
You are delaying the matter.
No, we are not delaying the matter because we have entrusted the entire contractual work to the Assam Police Housing Corporation. And some delay is also done by the contractor because in completion of the work. There is also.
we have not filed it.
Why the matter has been listed today?
Because earlier
You
on,
have been listed this type of matter. You seeing that no pleadings are complete. The pleadings are inadequate. The pleadings are yet to be completed. And under such circumstances, that the matter will be listed again on 15th of June 2026. In the meantime, the respondents are directed to complete their pleadings on or before 5th of June 2026. Liberty given to the petitioner to file reply on or before 12th of June 2026. Yes. Yes.
The labor matter, I respectfully submit report. Going into the matter, that is a big pieces laboring the small pieces. So, and this matter is around 20 years away. 20 years. They have been thrown out without anything.
What is the allegation? Where is the charge sheet?
Just, I see little indulgence for my constraint in my junior electors.
Yeah, no problem. Yes, where is the charge sheet?
Lordship, we have assailed this order mainly for one reason, Lordship. They have not framed the preliminary issue of validity of the domestic inquiry, Lordship. That's, Lordship, the Labour Court has not framed the preliminary issue at all. The basic thing which is required as of is has not been done.
In your written statement,
Lordship.
where is your written statement? Where is your written statement?
Annexure 5A, page 27.
Eight?
Lordship, 28A.
That is the workman. You are the management.
Lordship,
Are you not the management?
no, we are for the working, Lordship.
Then why will the preliminary issue be framed?
Lordship,
Preliminary issue is to be raised by them. As regards the fairness, who are you?
Lordship, the main contention itself is that they have not framed this issue. And without framing the issue of validity,
Question is, if it is not fair, then you are not prejudiced. What happens if there is a domestic inquiry is there, and the domestic inquiry is held against you, and thereupon you are dismissed out there? You will obviously say that the domestic inquiry has not been held properly.
yes,
Okay, very well, no problem. But they have the power to, without even a domestic inquiry also, they can do it. And at that point of time, they are to adduce evidence before the court to show that they have a case out there. And if you hold it that the domestic inquiry is not proper, then also we have a good case. Because if the domestic inquiry is held to be proper, then the industrial tribunal of the labor court would not enter into the merits, taking into account the fairness of the domestic inquiry. If they have not raised that issue, then how are you prejudiced? You are the
Lordship,
workman.
Lordship, by virtue of that domestic inquiry report, the opinion of that domestic inquiry report, we have been dismissed.
Understood.
Lordship.
Let us assume that there is no domestic inquiry.
Lordship.
Let us assume that.
Then they could have.
What happens when a domestic inquiry report which is there is held to be unfair? Then what happens?
Then fresh evidence could be led.
Was evidence not adduced?
Yes, Lordship.
Then
Then
come to the
without
point.
framing that basic issue of whether it's
If that is the case, we dismiss it right away. Okay.
Lordship, again, I have
Anything
been
else?
picked up out of 1,500 to 2,000 workers who were gathered there. Out of those workers, only 10 of us have been. It's a pick and choose
That
policy.
cannot be. I don't have those conscience that out of 1,500 here. My question is as to whether there is a perversity in the findings for which this court would interfere under Article 226. Where is the perversity?
Lordship, if we can put the charges, then Lordship.
Perversity is there. I've looked into it now. Page 14, I've looked into it. That on so and so, you along with others did not report for me and informed an unlawful assembly outside the so and so that you, along with the accomplices, also instigated various from the event that in so and so level charges of the event suspended from your duties, and during the period of suspension, you would be entitled to this allowance. And the findings of the inquiry report of the thing, and then let us see the written statement, what is the workman thing?
Lordship, it has been said again and again in Cooper Engineering as well as in Britannia that you have to first frame the preliminary issue. Only then you will get
Whose
the
instance?
Lordship.
At whose instance?
Lordship, since they
You
have
frame a preliminary issue at whose instance?
Lordship, the management has in their written statement there before the labor court said that if we be allowed to lead evidence.
But that is because of the constitution court judgment.
But here the labor court without jurisdiction, I mean, that jurisdiction comes only when you frame a preliminary, you decide validity. Lordship, if we can refer to Lordship, Karnataka State Road Transport Corporation provided the copy of the judgment, Lordship, where all these cases have been referred to. That labor court should first decide as a preliminary issue whether the domestic inquiry has violated the principles of national justice. When there is no domestic inquiry, there is no problem. But when there's a domestic inquiry and the dispute has been raised on the basis of that domestic inquiry, then it is the duty of the labor court to first decide on the preliminary issue of validity.
That issue is also decided.
Lordship, it has been decided after that, which is at the end, after leading evidence, Lordship.
So it is that. Looking with judgment says.
Lordship, if we Lordship can refer to Karnataka State Road Transport Act. That is a basic error, Lordship. To decide without deciding the validity and legality of the domestic inquiry, since the dismissal order was based on that domestic inquiry, Lordship. So it is obligatory on the part of the. We provided এটা set দিছো তাতে 10 নম্বৰ
But that is this judgment is on a different point. This judgment has no relevance for prayer. This judgment, madam, I tell you, this judgment is on the issue that at the time when you are submitting the written statement on behalf of the beneficiary, if you rely upon the domestic inquiry, we have also to be that look at if you are going to try to change the domestic inquiry, I should be given an opportunity to buy.
that is
That is the issue. Because the issue arose out here taking into account that there was a judgment by which the matter was referred, that whether the people in the case should be also on the basis thereof, not on the basis that as to whether if a preliminary inquiry is not held. Now, can you see that judgment which has been referred, not super engineering? We have referred to that judgment.
Then it's not. It's who there is that. Yes. Yes. There the issue is different of it.
No, finally, yeah, paragraph 13, paragraph 13, page 23, yes, paragraph 22 of the PCM. And people engineering.
Super engineering.
We should also make it clear what
Yes, yes.
that there will be no justification for any party to store the final explication by the tribal court by questioning its decision with regard to the preliminary issues of the matter it can be given a foyer. It will be also legitimate for the High Court to refuse to progress. We also I question it out there. If barely because of the fact that the preliminary issue was not framed, which was not insisted by the benefit. Because you see, the domestic inquiry is in whose favor?
Management.
If they don't insist on that, don't close. If they don't insist that you that kindly decide the preliminary issue as a preliminary issue, because the statement did not say that kindly adjudicate the area as a preliminary issue. Whatever is that. So if it is done, then what happens is cut short. That is the basic idea. If there is a preliminary issue, then you will not go into it if you only decide on the parents. But the fact that there is a preliminary issue, they don't inside of that, they think we are going to abuse evidence of in spite of them. And the court not failing it, why didn't you make it clear that you want to clear? Because you would never ask that the decision, but you are asking for decision in the merits. What is the reference made? A reference may be made on the basis of an industrial dispute. The industrial dispute continued, therefore the reference is being made in spite of the resolution being given by them by dismissing you with an industrial dispute. Therefore it is being made by the government. Now the reference says that whether the termination of these people were justified or not. Now what happens? The law is well settled to the effect that in strictly internal affairs of the company or anything, the court should not interfere or the industrial tribunal should labor court should not interfere. Provided, while doing so, there is a domestic inquiry, and the domestic inquiry is fair and reasonable and giving you all of the changes. Then you don't interfere. So therefore, what happens? The management always raises this. The time you deciding that the preliminary issue, then don't go into all these things. I'm not going to 1870. We have already the domestic inquiry. Therefore, another case is you see that judgment apart from that, there was earlier the judgment of this. Corporation, there was an earlier judgment. That at that point in time, you have to also request the court that look here, that if the domestic, the preliminary issue or the decision on the preliminary issue goes against me, I should be allowed to appeal the evidence. The reason is, it should not be delayed. There should not be a delayed adjudication, and thereby the bargaining power becomes such that the workman is not able to further continue with the proceedings. That is why in that paragraph also in this year, or in people engineering, you could say that the question filing with that you even cannot challenge a decision when a preliminary issue is being issued and decided that yes, the domestic inquiry is unfair. Then also you cannot come and decide. It can be only decided at the final awards. To your point, which you are trying to raise out here, not so good.
Lordship, that only when it is pending, Lordship. That issue comes only when the labor proceedings are pending, labor court proceedings, and a party comes against an interim order.
Why didn't you? Down to the fact. What is this?
Lordship, here we are only on the perversity because the Lordship, when the controversy is on the domestic inquiry, that is not fair. So when the dismissal, Lordship, it's a dismissal is a big thing, Lordship. That punishment is very severe. You are dismissing all of us on the on some charges which you have considered as Lordship. It has been proved against us, but we are also against that this does not come under gross misconduct, Lordship. That does not come under gross misconduct, Lordship. And that Lordship, we will definitely go to that, Lordship. But only my contention is that this yes, Lordship, we'll go to that too. But Lordship, I would still insist that if that dismissal is on the basis of a preliminary on that domestic inquiry report,
Consider
Lordship.
that to be a preliminary point, and I preliminarily rejected. Now argue on the main.
Lordship, I'll just provide another judgment. I'll go to that. Well, our case is entirely covered by this. The three errors committed by the learned labor court, Lordship.
Yes. Show me one that very in the Supreme Court state at the instance of the workmen where that a domestic inquiry has to be taken as a preliminary issue first. So one way.
Worship,
Because you see, why I'm saying so, as I said it to you, the fairness of a domestic inquiry is being taken up always as an issue by them, by the manager. And it's up an issue of them to kindly decide. Finally, decide the fairness of the inquiry, and therefore, if necessary, give us the evidence and an opportunity to review. This is what is given by them. This is how. If you see in the case of Kurukshetra, you see in the case of ML Sikna, all these cases, whatever we do, are cases wherein the preliminary issue was not framed by the labor court or the industrial tribunal, and there was a request being made and went directly into the issue of this. It is never done at the instance of the workman. Because later on, if they don't make that issue, they cannot deal with it.
I would still humbly submit that since the dismissal or any other, dismissal or any other punishment, if it is based on the report of the domestic inquiry, it would be my right to object to that or say that this inquiry report is vitiated or against the principles of natural justice. Because my
Okay, let us see. Let us see that the award has nothing to say. Let us just close our eyes in respect to other issues. Only take up the issue where the court has decided on the domestic. There's been held to be fair. What is the purpose?
perversity,
Are you there? You are insisting on that issue. But the fairness of the area. Let us not look into other. Let us look into the domestic. See what happened. In all these cases, the domestic inquiry, the fairness of the domestic inquiry have not been adjudicated. See, on all these cases. These are not the cases where fairness of the domestic inquiry is being adjudicated along with the other issues.
Lordship in Firestone, it was laid down that the tribunal gets jurisdiction to consider evidence placed before it for the first time in justification of the action taken only if no inquiry has been. But inquiry has been held. So why would you want to take fresh evidence or need fresh evidence? If because the management in its written statement said that in case the domestic inquiry is found to be vitiated, then we should be allowed to read evidence. But the learned labor court has not even framed that preliminary issue first and neither decided that it has straight away gone to the evidence. It has allowed both the parties to read evidence without even deciding whether it's. So that was not necessary since there was already, they've laid evidence, both the parties. There's evidence before it. So without deciding whether the domestic inquiry is fair or not, there's no necessity of going to the evidence part, Lordship. That is my humble submission, Lordship. If there's already a domestic inquiry report and there is evidence which was led and at that stage, Lordship, Firestone facts, Lordship, and in the Karnataka road transport only, it was effort. I'll provide you a copy of Lordship. Provide a copy, Lordship.
When?
No, today itself.
Now,
Now, because since evidence has already been led, so there's no need of fresh evidence. Only if the domestic inquiry is found to be vitiated, then they have stated in the written statement that if the domestic inquiry is found to be vitiated, then we may be allowed to lead evidence. So that is what it has been reiterated in all these cases, whether it's Shankar Chakravarti, whether it's Cooper Engineering or Firestone, that you will get the jurisdiction to decide on the evidence or lead fresh evidence only if you find the domestic inquiry vitiated. Without,
Understood, but maybe that is understood. But here, in the case of ML Singh now, the court also said out there was initially what happened? The Labour Court said that everybody gave evidence. Everybody gave evidence. Then what did he? The Labour Court did not decide on the domestic inquiry and held the domestic inquiry to be bad, and thereupon finished and said that okay, they are entitled to 50% damage. Issue involved there in a look here. I would have maybe given certain further evidence to support the justification that apart from the domestic inquiry, there are other materials also. And as such, without considering that, how can you do so? That was the issue. So therefore, it is again an issue raised by the many. And therefore, I'm asking you, therefore, when you make the submission, let's first look into the affidavit filed by the management. I thought that you were the member. But the workman raising such an issue, I've never heard about.
because we have been dismissed based on the domestic inquiry, that's why it is our dispute that this domestic inquiry is
See,
vitiated.
you had participated all along, even evidence, everything were going on. The issue is to be normally raised.
Because it is our dispute that this domestic inquiry was not fair. But Labour Court, Honourable Labour Court, that is a technical issue, Lordship, that without this is a settled law, Lordship, that without even, deciding on this basic question, how can you allow the parties to lead evidence again? That was not accepted.
Well, that has been held to be good by the ML Singer.
But
Say that can be done. ML Singer say, when it's the ML Singer say, assuming that the Labour Court had the jurisdiction to direct the parties in the first instance itself to adduce evidence on merits in support of the charges, yet in our opinion, it was obligatory upon the Labour Court to first frame the preliminary issue on the question of validity and the legality and validity of the domestic and confine its discussion only for examining the legality and propriety of the inquiry proceedings. Then,
that's what we are raising, Lordship.
but this is at the instance of again the management. My question is therefore this: can this be a plea taken by the workman?
Yes, Lordship, absolutely.
Where is that?
Because
Show me
that is
there.
Lordship,
No, all these judgments are raised by the management.
Lordship, maybe that is because the decision or the domestic inquiry report
Because
or
the domestic inquiry always goes against the workman.
correct, Lordship, it may sometimes.
Obviously, that is why there is the reference, unless
Most cases,
at the instance of the management, references are not normally made against the work. Yes, there might be amongst the employee, or in other cases between the management and something, there might be a reference as regards that. But as regards dismissal of a workman, there's no reference being made at the instance of the management. It is always made at the instance of the workman.
Yes.
So the workman, therefore, if you see section 2A, capital A say that if a reference is not being made, an opportunity is given to you to decide to file an application directly, questioning the dismissal. So therefore, you are to always say that the domestic inquiry is bad. And in fact, that is your stand. I understand why you are raising that issue. The raising issue is because in the written statement, you only said about the domestic inquiry and nothing as regards the charges. I understand why you are making this up. You cannot go traverse beyond that because you have a very limited written statement. Mrs. Vatsegi, what do you say on this point? You are an expert in this labor law. Because as I have done in many matters also, I could see this is a point which is also urged by the management. That the domestic inquiry preliminary issues is not being framed. Because they don't want to adduce further evidence. They say that on these facts or these evidence which are there, it was sufficient to dismiss. So kindly decide like this. And if necessary, we are going to adduce further evidence. This is what Karnataka, state of Karnataka Transport Corporation says. You have to take that plea in your written statement. That is it. But have you ever heard of the workman taking up the plea that kindly formulate? I've never heard about this because normally the workman will always say that the domestic inquiry is bad. So they would never ask that kindly decide on the day, thereby saying that throw me out at this instance. Get a point? Yes, please. Mr. Thakur, my point is not on that. My point is, can you raise that issue as a workman? That because of the fact that the domestic inquiry is not framed, the premium issue is not framed as regards the fairness of the domestic inquiry, the entire proceedings which have been decided against you, including the fairness of the premium inquiry, yeah, gone. Can you take that as a workman? Yes. As a management, they can, because they have a chance. But can the workmen say that? So we are only speaking to this, because normally filing of the pleadings is prior to the decision on the framing of a preliminary issue. Now, in your pleadings, which you have done, you have not raised anything to that effect on the charges. You only say that domestic inquiry, domestic inquiry, domestic inquiry. I thought because you were saying this in the context of my other series of matters which I was taking, not in respect to this series. Anyway, what do you have to say on the other?
Lordship, again,
You have been terminated.
but
You have been terminated
yes, Lordship,
on the ground of instigation
instigation.
because the instigation has been proved.
Lordship, the proof is not correct, Lordship, because if your Lordship refers to the evidences against me,
Hmm.
the evidence of MW2 and MW3, Lordship will be shocked to see that. If your Lordship can refer to that.
Yes, tell me.
Lordship, the MW2 has said that I do not know, I don't know which worker has specifically done any of these allegations,
Who is MW2?
actions.
Huh?
Lordship, MW2, Lordship.
Yes.
Evidence of MW2.
Wow. Who is MW2?
Look at page 42.
The clerk.
Page 42.
Is the head clerk. Warjanti state. He has been
Warjanti
working in the state state from 96 on so and so was a knockout at the time of the late incident of the preference. He was present the day of the incident about so and so. Many of the workers were assembled near the out of Dharna. The gate was closed. We did not see as to how the gate was open. All the workers entered through the
Para 14.
surrounded the office, but he did not know the gate was open. At that time, he inside the office, the workers started to break the glasses. The workers entered the office were breaking lock. They then, thereafter, they went to suddenly he heard outside firing down inside the office room. He then went to his quarters, which was charge sheet was issued. Some of the workers who was present in the was started against the workman and finally the workman will dismiss. He narrated that he's faithful to so the notice was harming he has not stated that he will evidence in chief. The evidence to the management has stated about the change in management. So, but he how is his evidence relevant?
Worship,
He has not indicated who is these people.
Worship, he has specifically said in the last line, Mr. Sanjeev Das was the manager at relevant time who was not cross-examined. It was alleged that this Mr. Sanjeev Das, who was the manager at the relevant time, he was injured. But there's no medical evidence to prove that he has not been examined or cross-examined. So all the allegations are based on this, Lordship. And then, Lordship, MW2 has said that
That
he
is
did
too
not-
far-fetched, madam. Too far-fetched. We are in a tertiary jurisdiction.
Lordship, I
Too
understand. Lordship,
far-fetched.
but if this person has said that I do not know who has particularly done what, then if you have led evidence, fresh evidence against me, and where you are saying that I do not know who were the workmen and what did he do, then how can I be punished for this? He did not know if any workman had taken leading part in the incident. This is his evidence, Lord. This is his statement. Out of 1,500 to 2,000 workers who were gathered there, he does not know which particular workman did what. He ran away. MW2 and others fled away. So if you seek to dismiss me, punish me on the basis of these statements, then these are contradictory to what has
So
been.
you say that you were not present.
Lordship?
Are you saying that you were not present?
Lordship,
That
yes, Lordship. I'm saying that I'm not saying I'm not present. I was present there doing a peaceful dharna there.
Huh?
These 10 workers, none of us were involved in any rioting or any violent act, Lordship. That's what I'm saying, Lordship. All the workers were present there because there was a notice which was on there saying that they don't even know because it was in English. So this chaos was because of that. They had gathered there just to understand what is this notice all about.
Okay.
And then there was only a peaceful demonstration or peaceful dharna. And out of it's visible in the videos, out of those 1,500 to 2,000 workers, 10 of us have been picked up, which is discriminate, and they have discriminated against us, saying that these are the 10 workers. When the evidence of these.
when you're here, I see that here, but very difficult for you. That we can speak when you have one questions. Your name?
Workers,
What is your name? Tanti.
one is Tanti.
Rita Tanti.
Uh,
Workman number 2.
We have 10 of us. Rajesh Kurmi, Rajen Karmakar, Dilip Tanti, Purneshwar Karmakar, Bablu Tanti, Rupeshwari Tanti, Jamuna Karmakar, and Daima Tanti. Vimoli Karmakar, Anjana Tanti. and Anita Tanti. Tenants. Para 10 of the award says, during the course of management evidence suggested that none of their witnesses had identified the delinquent workmen.
Yes.
submission is first, my lord. The domestic inquiry was conducted. Evidence was laid during the domestic inquiry. The lordship comes to page number 18, para number 9. Sorry. Here, my lord, the witness for the management was the Sri Rajeshwar Kurmi. He was the Sardar of Borazam Tea Estate. In his evidence,
You cannot rely on the domestic inquiry now, but because of the fact that you did not raise that issue to be decided at the.
yes, I'm not on that.
So let us forget about domestic inquiry. Let us take the case of Delhi, because the moment I hold that you look into the domestic inquiry, then my arguments might seem. Therefore, you are therefore to put before the court. Therefore, how you identify each person fully? Because I look into your evidence. The person, the American witness number one, he didn't know everything. Even he went to the extent of stating out here in his cross-examination. I mean, his cross-examination, MW1. He says the management of the displayed one notice offering the shares of the garden of all the employees to the purchase the shares of the garden. But unfortunately, due to a misunderstanding of the contents here, the incident took place amongst the work. He says that he doesn't, we have not seen Sandeep Das.
Yes,
Sandeep Das has not come to be evidence.
because
You
it-
identified the villager. Where is the evidence?
evidence before the level two.
I'm looking at the evidence. Where is the evidence that you have identified this people? The definitely one say, then look here, I was there, wait man. I was sitting on the backside. Those persons came over to the backside of the. I did not go there. In the cross, he didn't put a single word upon it. That it is a perversity to say the same. Because the court went into the full merits. The moment he decided on the merits, how did the labor court identify that these are the persons concerned?
My, page 44, my lord. Page 44. Management witness number 4. It was,
Management witness number 4 is the inquiry officer.
yes, ma'am, inquiry.
What did he say?
During an inquiry, the independent observers presenting the officer and also the delinquent of workmen were present. Initially, the charges were explained to the workmen and then their answers were recorded. Officer, the presented officer presented the case and also conducted the case on behalf of the management, and after recording the sheet of the management witness, the workman was given opportunity to cross-examine the management witness. He asked the workman.
Mr. Counsel, I hope I'm able to make you understand. Here is the case. The petitioner out here say that look here, you should have decided the preliminary the inquiry is a preliminary inquiry. And if you don't do it, then the entire proceedings you could not have proceeded with. I say that can the workmen raise that issue? It is left with the management to raise such issue. But the management did not raise such issue and proceeded to give evidence. The moment you proceed to give evidence, the court cannot then look into it, into the domestic inquiry, without first deciding as a preliminary issue as to whether, as regards the fairness. The domestic inquiry cannot be looked into. What can be looked into is the other evidence. Where is there evidence identifying these persons? No evidence. Perversity. Now, madam, tell me, which point do you want to?
Mainly, all of them, Lordship. This all go in my favor, Lordship.
You read the first point. Let them, I allow them, say that it is bad. Remand it back there.
No,
Decide. And they will get the evidence.
Lordship, I'll go with the second issue, Lordship. Lordship, I'll go with the second. Second one, Lordship, the charges have not been proved and workers have not been identified, Lordship. None of them.
You have to agree.
I think as the first issue, it will be clear, my lord, because the other record says, my lord, he did not respond to the so-called notice and all these things are here.
You say the second so-called notice has not been responded to.
Yes,
It's okay. Second so-called notice has not been responded to by doing the. But then also, once you are not relying for the domestic inquiry, are you relying upon the domestic? Yes, madam. Huh?
the order says so, my lord.
No, I'm asking you, are you relying on the domestic inquiry or not?
Yes, my lord.
If you're relying on the domestic
Yes,
inquiry,
madam.
then the fairness of the domestic inquiry has to be adjudicated on the basis of the material which are already there. Not
Yes.
on other evidence.
Then the paragraph number 14 of the request, my lord, I have to raise this issue. Paragraph
So
14 of
therefore, you also say that the preliminary issues should have been created. I say
The-
that.
my lord, the management submitted that he want to rely on the domestic inquiry held by the management.
Therefore, if you're relying on me, then the court has to first adjudicate without going to other evidence.
Yes.
The court did not adjudicate. Then you can do judgment apply.
Yes.
What do you want?
It may be given a committee. That issue may be the same one.
Lordship, the labor court order, award itself is perverse, Lordship. Labor court order in any ways is perverse, Lordship. Both ways.
12 o'clock, we think sun now at 12 o'clock, ships start aside, you are now. It's changing your competition from take. Well, let me come back in 5 minutes. MW2 say at the time of the alleged incident, the reference he was present on the day of the accident. Many of the workers of the temple near the factory, the gate was so and so. He did not see how the gate was open. All the workers entered through the gate, surrounded the office of the manager, but he did not know how the gate was open. The workers started to break the ear. They locked the door. The workmen entered inside the office by breaking the locks. Thereafter, MW2 or the others fled away. He heard from the room outside fighting inside the room. He then went to his quarter. He saw from his quarter that the police took over the manager from the room. Lock and the charge sheet was issued to some of the workers. He was present in the event. They were started against the workmen and finally workmen here. Notice was hung. He did not remember the name of the workman under reference. He denied all that all the workmen on the reference were the members of alia, 2 members of the wheel. When the filing started, he left the office. He did not he had filed. He did not know which particular workman had committed the offense, such as breaking the finger. So MW2's evidence is useless. She says he was a typist. Before the domestic inquiry, he did not know who had committed the offense of entering into the office and breaking the window panes of the air. He thought the incident took place due to the change of the theme of air. Nobody identified. Specifically, nobody identified. That's so then without identification, it is already said that it is around 1,500 to 2,000 workmen were assembled out there. So how can you could identify them if the evidence to be reduced? Yes, because now tell me, we are almost 20 years down the line. How many have how many can be reinstated?
Lordship,
Question of reinstatement may not arise. Then the question of whether they are engaged somewhere or not, that is another thing. I'm not on that. The question is how many can be reinstated taking into account the evidence. See the evidence. See, this person concerned executive to one was 52. Dilip Tanti was he a part of the workman?
yes,
He's
those
52. He cannot be now done. Next one is Bablu
Bablu
Tanti.
Tanti.
He's also a workman.
what
52. Upeswar Tanti. He's 40. He's also gone. Himali Palmakar, 40 gone. The year when was this?
6,
2015.
6 and 2015.
Now, what is the age of retirement? 58. 58. As per the standing order? 58. This is the standing order for where is this? This is the Golaghat. You'll be following the Assam Valley and Suma Valley. Yes. Standing order. Sure. I have to verify it.
Dismissed way back in 2007, Lordship. It dismissed way back in 2007.
But
20 years.
So here, what they did, the court did not go into any other issue or merit. Only decided this issue on preliminary inquiry. So it's a preliminary inquiry done. They did not frame an issue. That's a different thing. But what was decided was only the domestic inquiry.
Yes. The entire award was based on that, the domestic inquiry.
Domestic. So they did not go into the merit.
Yes. Uh,
Indeed.
fresh evidence was led, and based on that,
Evidence was led, it's okay. But the decision is purely on the domestic inquiry. So it will be therefore a decision out here is as to whether the court was justified in dismissing, in rejecting the reference only on the basis of the domestic inquiry.
the charges also could not be proved, Lordship. The charges, again, in the Lordship, the Labour Court has discussed on issues were framed, Lordship.
Huh?
Issues were framed by the Labour Court.
It's okay. But what was decided was only the domestic inquiry. He did not go into any other evidence. So therefore, it is only on the question of domestic inquiry the question was done.
Yes. Without framing the preliminary issue, whether it is.
So therefore, let us see only the evidence of the ended court.
Fresh evidences were taken to decide whether they have committed the alleged charge acts. So the Labour Court has decided entirely on the basis of the evidence led before it.
Now, what is being stated by the clerk in the evidence before the domestic inquiry is different from what he has stated before the industrial tribunal.
Absolutely correct. Both the statements are different.
He, in his cross-examination, categorically says that he doesn't know anybody who were present.
Because it was properly cross-examined, Lordship. Said whatever is the Lordship. Out of 1,500 to 2,000 workers, they couldn't identify, they could not say that these particular workmen leave. There's no medical evidence to prove anybody was injured. And their witness home
I
said
think
that
this is a case for remand. Remand for deciding because they have not decided anything. It is only the previous.
we are not even aware whether they are alive or not, because they've not been in contact.
Understood, but I can't look into that because they have only decided the preliminary issue. Preliminary, right? So the preliminary issue has been decided, although all evidence have been assumed, but only the preliminary issue has been decided. The court did not look into it. Let the labor court decide on that aspect.
Lordship,
Because the inquiry report I've looked into, it is goes against all rules of what is the term used? Well, the natural justice too there, but there's another ground which is normally being taken.
but remanding back, not such the purpose.
Rule recognized by any law.
Lordship, we are not even aware of the status of any of them, Lordship, because the clients are not even in contact, with laborers, whether they're alive, whether they, under what condition.
Here on behalf of the union.
Lordship, the union members, few of them are there, others expired. Those.
No, union, you are on behalf of the union.
And
So therefore, I think it is a case for remand, taking it as a decision have been decided only, this will be taken only as a preliminary issue. And we find that I put into the inquiry report, it goes against all norms of judicial procedure. And also natural justice. And perverse.
should be
It's
labor court.
absolute perverse, taking into account that nothing is there. There is no identification as to who was the
Lordship.
person concerned. So therefore, there is the direction to decide the other reference within a period of 60 days or 80 days. I think that or Ms. So-and-so, the learned counsel appearing on behalf of the petitioner. If the so-and-so appears on behalf of the respondent, for what? Number one. At the outset, this court would like to strike out the name of the respondent number two from the array of parties, taking into account that it has been always it's well settled that a judicial officer an officer who exercises judicial powers ought not to be arrayed as a party to the proceedings. In fact, the Supreme Court in this regard have deprecated such practice. The present petition has been filed. Assailing the award dated 29/2/2016, passed by the learned presiding officer, passed by the learned Labour Court, Dibrugarh, in reference case number 02/2009. Whereby the reference which was made by notification dated 2011/2008 was answered, holding in the alia that the management of Morchan Estate was justified in dismissing the services of the workmen and that these workmen were not entitled to reinstatement with full back wages. Before taking into account taking note of the impugned award which has been assailed in the instant proceedings, this court finds it very pertinent to take note of the brief facts which led to the proceedings. That is reference case number 02/2009. On 23/2007, at around 7:30 a.m. Around 1,500 workers assembled in front of the workers of the Borjan Pisti, assembled in front of the factory gate and made the outcry. Some of the workers thereupon forcefully entered the factory compound as well as the office of the manager by breaking the lock of the gate in spite of resistance given by the security men. And started shouting, pelted stones, damaged the furniture and fixtures of the office. The then manager, Mr. Sanjay Das, also sustained serious injuries. It is on account of the police having intervened the situation it is on account of the intervention of the police. The incident which took place was subdued. This resulted into a lockout of the Borjan estate for a period of 11 days. How many workmen?
10 workmen.
Thereupon, ten workmen were issued charge sheets. On 7/4/2007, alleging inter alia that these workmen were responsible for instigating, for having an unlawful assembly, for forming an unlawful assembly outside the garden gate, and instigated the other workers to form the unlawful assembly outside the office. It was also alleged that these workmen, MEN, had also incited the workers, other workers to pelt stones at the office. And on account of their further instigation, a violent situation arose, came into being, which not only led to the damage to the garden property, but also trespassing into the manager's office and rampaging, rampaging and breaking the office furnitures and other valuables. It was also mentioned that On account of such actions on the part of the workmen, the management suffered loss to the tune of rupees 1,196645, 19,06,450. Under such circumstances, these workmen were charged for willful insubordination, riotous conduct, inciting others to disturbance and violence and willful destruction to garden property, which amounted to gross misconduct in terms with clause 10, small a, Roman 1, Roman 7, Roman 8, and Roman 11 of the standing orders in force in the state. All these workmen thereupon submitted their replies, stating inter alia that they were nowhere connected with the incident. Though they were present amongst the various other workers of Borjanti state. One of the workmen, namely Dilip Kanti, who was the gateman, had categorically stated that the gate in question was broken open by some of the workers and overpowered him by overpowering him. The management being not satisfied thereupon, appointed one inquiry officer to hold 10 domestic inquiries against the 10 to hold 10 independent domestic inquiries against the 10 workmen.
One petition, Lordship, there are 11 workers, just one time, 11.
11. In pursuance to such the inquiry officer therefore made inquiry and submitted 11 domestic inquiry reports. Holding inter alia, opining or inter alia that all these workmen were guilty of gross misconduct. Inasmuch as per the inquiry officer, the workmen, that inquiry officer, the management have proved beyond reasonable doubt that these 11 workmen were guilty of gross misconduct as alleged in the charge sheet. The reports further reveal that pursuant to the inquiry reports received, notices were issued to each of the workmen they were informed to submit representation in writing as to why and prior to a final decision is being taken by the management. It was also mentioned by these notices which were all dated 16/8/2007, that in the circumstance no representation is submitted, it will be presumed that the workmen would have nothing to submit, and the management would dispose of the case in a manner deemed appropriate. The reports further reveal that pursuant thereto, the workmen sought for time by filing a representation, and accordingly, the time was extended to 28/8/2007 by separate communications issued to these 11 workmen on 21/8/2007. Subsequent thereto, on 8/9/2007, all these workmen were dismissed from service as no representation was submitted. And on the basis of the domestic inquiry reports, on account of the dismissal of these 11 workmen, an industrial dispute having arisen, the appropriate government, the government of Assam, in exercise of the powers under Section 10 of the Industrial Disputes Act 1947, made a reference to the learned Labor Court, Dibrugarh, by the notification dated 20/11/2008, the schedule of the said reference, which contains of the notification, which contains the terms of the reference being relevant, are reproduced herein under page 22. Upon receipt of the said notification, a reference proceedings was instituted, being registered and numbered as reference case number 2/2009. Pursuant thereto, written statement was filed by both the management as well as the workmen. Before further proceeding with the proceeding with the narration of the facts, This court finds it very pertinent to take note of the written statement which was filed by the management in the said reference proceeding. From a perusal of the said written statement, it appears that the management narrated the incident which led to the dismissal of the concerned workman. It was categorically mentioned at paragraph number 5. Six and 7. Stating inter alia that impartial domestic inquiries were conducted on different dates at Borjanti State after issuing notice of inquiries upon all the workmen. It was further mentioned that the domestic inquiries were held separately in full conformity with the principles of natural justice and found all the workmen guilty of the charges as stipulated in the charge sheet. It was further mentioned that pursuant to the receipt of the domestic inquiry, the petitioner, the management, did not find any extenuating circumstances to take a lenient view in the case of the workmen, and accordingly, these workmen were dismissed from service with effect from 10/9/2007. It was further mentioned that the dismissal of the workmen from the service was fully justified and that the workmen were not entitled to reinstatement at their service or any other relief. Paragraph 14 of the said written statement being relevant is reproduced here in under page 25. From a perusal of the said paragraph, above quoted paragraph, it will be seen that the management reserved the right to rely on the domestic inquiry held by the management and thereafter intended to adduce further evidence on merit if the domestic inquiry is found to be violative of the principles of natural justice. The workmen also filed an written statement wherein it was the categorical stand of the workmen that the domestic inquiry was not impartial. And in fact, the domestic inquiry was perfunctory, as no opportunity was given to the workmen to adduce defense evidence. It was categorically mentioned at paragraph number 5 that a workman did not instigate other workmen together in front of the office or in pelting stones at the office or becoming violent or breaking window panes or abuse management staff as alleged by the management. It was categorically mentioned that once we became who are the presenting officer on behalf of the management in the domestic inquiry, has also adduced evidence for the management in the domestic inquiry. And as such, he had not remained as a presenting officer alone, but he had also acted witness. It was also mentioned at paragraph number 13 of the written statement that on the date of occurrence, the entire employees of Borjan estate abstained from duties, but the management has alleged the workmen under reference have instigated the entire workers of the workmen. The reports reveal that initially the said reference proceeding was proceeding ex parte. And on account of non-appearance of the workmen, the award was passed. The notice to the If the written statement was filed to the workmen on 4/1/2015. Instead of formally training a preliminary issue as on the question of legality of the domestic inquiry upon which the management of the respondent state was laying emphasis upon. The learning labor code proceeded to agree, proceeded to record evidence. It may be pertinent to mention that the instant the referee proceedings initially were proceeding ex parte against the workman. And at that point of time, the management of the respondent state had submitted the evidence on chief. By the court, by the order dated 16/2013, the management of the respondent would categorically mention that they would not like to further exclude any evidence, and thereupon the proceeding was fixed for cross-examination of the management witnesses. The report further revealed that subsequently, the management side, the management filed another petition to allow adducing further evidence for the therefore evidence of the what side was also accused. On 2016, the impending war of in the backdrop of the above, let this court Consider the submissions who were made by the learned counsel, and take note of the submissions who were made by the learned counsels appearing on behalf of the parties. Miss So-and-so, the learned counsel appearing on behalf of the petitioner, submitted that in the instant proceeding, the learned labor court committed a jurisdictional error in passing the award without first framing a preliminary issue as regards the legality or validity of the domestic inquiries so held against the petitioners, against the workmen. The learned counsel submitted that pursuant to a decision so rendered as regards the question of on the question of legality and validity of the domestic inquiry being pursuant to such decision being rendered on the legality and validity of the domestic inquiry, and if it is held that the domestic inquiry has been done, inquiries were conducted in the manner recognized by law, and in the manner provided by law. It was also the second jurisdictional error so committed by the learned labor court is not deciding on the question of proportionality of the punishment, which ought to have been decided by the learned labor court. The learned counsel therefore submitted that the imperial award is required to be interfered with on these two jurisdictional errors committed by the learned labor court, and in that regard have referred to the judgments of the Supreme Court in the case of Manchester University versus Singh, reported in 2018 for SEC 483, as well as the judgment, as well as the case of NL Singla versus Punjab National Bank and others, reported in 2018 18 SEC 21. The learned counsel appearing on behalf of the petitioner further submitted that it has been the constant stand of the respondent, of the workmen, that they were not a part of the said mob which pelted stone or vandalized the properties. The learned counsel submitted that admittedly, from the evidence on record, it would be seen that around 1,500 to 2,000 workers were present at 7:30 a.m. on so and so. And on that very day, and out of that, some of the workers committed such mischief. The learned counsel submitted that in the entire evidence which is on record, there would would be shown that the petitioner, the workmen in the instant case were involved in such incident. The learned counsel further submitted that the reliance had been made by the learned inquiry officer in the domestic inquiries on the evidence of the head clerk. However, the evidence of the head clerk, which was recorded in the domestic inquiry so held, were not exhibited before the learned labor court. The learned counsel further submitted, drawing the reference to the evidence of MW2. MW2, na? MW3 is the typist. MW4 is the employee, the inquirer. MW2 and submitted that during his cross-examination, he categorically mentioned that he do not remember the names of the workmen who were involved in the incident. He therefore submitted that this is a case where this is a case wherein interference under Article 2 to 6 of the Constitution is required in exercise of the tertiary jurisdiction of the court. Mr. So-and-so, the learned counsel appearing on behalf of the respondent, management, on the other hand, submitted that the incident took place the incident took place after an unlawful assembly at 7:30 a.m. on so-and-so, which resulted in not only vandalizing the properties of the respondent of the management estate, but also injury to the manager. The learned counsel submitted that the domestic inquiries which were carried out were done properly and by following the mandate of by following the principles of natural justice. Adequate opportunities were granted to the workmen, and the failure on their part, in spite of opportunities being granted to adduce evidence, cannot be a ground to hold that the domestic inquiries were not done in the manner and beside the law. The learned counsel appearing on behalf of the respondents respondent number 1 further submitted that the contention that the learned counsel appearing on behalf of the petitioner that there was a jurisdictional error in not deciding, in not framing a preliminary issue as regards the legality and validity of the domestic inquiry, has no legs to stand, taking into account the workman name, taking into account that a perusal of the impugned award would show that the learned labor court had only decided the legality and validity of the domestic inquiry and thereupon upheld the decision of the management in terminating the services of the workmen. He therefore submitted that there is no case made out for interference in exercise of the tertiary jurisdiction of this court. Let me not spoil your lunchtime.
My lord, before your lordship start the proceeding, my lord, I would like to mention, my lord, item number 4, which has become infractuous. First, my lord, before the mediation, matter was referred to the mediator, my lord, and matter has been resolved. Dispute in between the parties has been resolved. So, my lord, in that line, your lordship may dispose of the late petition, my lord.
I can wait for 15 minutes. We'll push. Could have heard the learned counsel appearing on behalf of the party. Have perused the materials for the report, including the report of the reference case number so and so. The narration of the facts herein above and a perusal of the impugned award show that the learned labor court did not specifically frame a preliminary issue as regards the legality and validity of the domestic inquiry held against the workman. It is appositely out here to mention that at paragraph number 14, paragraph number 5, 6, and 7, as well as at paragraph number 14 of the written statement filed by the management. The management had been filed by the management. The legality and validity, the domestic inquiry the inquiry reports, the reports of the domestic inquiries were relied upon by the management to justify their stand for dismissing the workmen. Under such circumstances, it was the requirement of law that the learned labor court ought to have formally framed a preliminary issue before preliminary issue on the legality and validity of the domestic inquiries held against the workmen. This would also find it very pertinent to observe that the perusal of the impugn award showed that though there was no preliminary issue framed for as regards the legality and correctness of the domestic inquiry reports. But what was decided in the inquiry report, in the impugn award, was only the legality and validity of the inquiry report, the reports of the domestic inquiries. The London Labour Court further did not proceed to decide anything else. It further surprises this court that to take note of that the London Labour Court, while passing the impugn award, after having held the domestic inquiries, after upholding the domestic inquiries held against the workmen, did not decide as regards the legality and validity of the punishments which have been imposed against the workmen, which was a jurisdiction which was a jurisdiction conferred upon the Learned Labour Court to decide, and the Learned Labour Court failed to do so. This appears to this court to be a serious case of jurisdictional appears to be a serious case of a jurisdictional error committed by the Learned Labour Court. In this regard, this court finds it very pertinent to take note of the judgment of the Supreme Court in the case of M.L. Singla Supra, wherein the Supreme Court observed the procedure to be followed when a domestic inquiry is being relied upon. Paragraph number 12 to paragraph number 27 being relevant are reproduced during under. The proposition of law as laid down by the Supreme Court in the aforementioned paragraph clearly showed that when a domestic inquiry is being relied upon, was the requirement of law that the premium should be framed as regards to legality and validity of the domestic inquiry report. And thereupon, if it is held that the domestic inquiry reports are in order, then to decide as to whether the imposition of punishment was proportionate. In the instant case, it could be seen that the London Labour Court, by the impugned award, only decided as regards the legality and validity of the domestic inquiry report and held it to be fair. Taking into account the submissions so made by the learned counsel appearing on behalf of the petitioner, this court finds it pertinent to take note of. Pertinent to look into it as to whether the domestic inquiry, as to whether the opinion rendered by the learned labor court holding the domestic inquiry to be fair is in consonance with the well-settled principles of law. From the perusal of the materials from the court, and more particularly the evidence adduced by the management witness number 4 before the learned labor court, who was the inquiry officer, he, during his cross-examination, categorically mentioned so that though information was provided to the worker by him as regards workmen, as regards the appointment of an inquiry officer and to participate in the domestic inquiry proceeding. But during the cross-examination, he has categorically mentioned that he did not inform the workmen that they are required to adduce evidence. In fact, during his cross-examination, he mentioned that the presenting officer be informing the workmen that they were required to would inform the workmen that they would be required to adduce evidence. This court also finds it very surprising to take note of that without the records of the domestic inquiry being placed before the learned labor court as to how the evidence has been adduced and as to whether the observers were present, which would be seen from the minutes recorded during the course of the domestic inquiry, the learned labor court came to a finding that the domestic inquiry was held in consonance with the principles of natural justice. court also finds it very relevant to take note of that the evidence on the basis of which the inquiry officer had decided that the workmen were involved in the mob which led to the which led to the incident was on the basis of the evidence of the head clerk. The said head clerk had adduced evidence as NW2 before the Learned Industrial Tribunal. And during his cross-examination, he had admitted that he does not remember the names of the workmen who were present, who were involved in the said incident. It may not be out of place to mention that the facts in the present case would show that there was a gathering of around 1,500 to 2,000 workers of the Borjan tea state. And out of that, some were involved in the incident. The Learned Labour Court, having taken the evidence of having permitted the management to adduce evidence, and the management having stated during the record of the proceedings on 16/3/2015, 16/5/2013, that they would not like to further adduce any evidence. The Learned Labour Court ought to have taken into consideration the evidence given before the Learned Industrial Labour Court by the management witness number 2 before the Learned Labour Court, which formed the basis of the decision of the inquiry officer in the domestic inquiries. This aspect was not at all considered. This court also finds it very pertinent to take note of that the perusal of the inquiry reports of the domestic inquiry held against the workmen, the inquiry officer did not even care to give reasons as to why the petitioners here, the workmen, were singled out, that action was taken only against the workmen. A perusal of the inquiries of the domestic and the inquiry reports further reveal that after recording the evidence and the procedure followed, the inquiry report was the inquiry officer held that the management had proved the case beyond reasonable doubt, the charges beyond reasonable doubt. The above analysis of the inquiry report not only shows that it is in conflict with the principles of natural justice, but also appears to be perverse, but also perverse It is therefore the opinion of this court that the learned labor court ought to have therefore rejected these inquiry reports and thereupon ought to have proceeded with the decision inquiry report, the reports of the domestic inquiries, and proceeded to decide on merits on the basis of the evidence which was available, inasmuch as the evidence of all the parties were taken prior to the award was passed. Considering the above, it is therefore the opinion of this court that this is a fit case for exercise of jurisdiction under Article 2 to 6 of the Constitution to interfere with the award dated so-and-so, passed in reference case number so-and-so. Accordingly, the instant petition stands disposed of with the following observations and directions. The impugned award dated so-and-so is set aside and quashed. Number two, the inquiry reports that the reports of the domestic inquiry which have been held for the workmen are set aside and quashed. For the grounds and reasons, for the reasons already above mentioned. Number three, the learned labor court is directed to decide the reference proceedings, decide the terms of the reference in terms with the notification dated so-and-so. On merits, on the basis of the evidence which is available on record, taking into account that the incident happened sometime in the year 2007 and almost 19 years have passed in between. This court directs the learned labor court Dibrugarh to decide the said dispute despite the said reference proceeding as expeditiously as possible and preferably within a period of 3 months from the date of appearance of the parties before the learned labor court. Taking into account that the parties are already present before this court, the parties are directed to appear before the learned labor court on 8th of June 2026 for further proceedings of reference case number so-and-so. The registry will have it on 22nd of June.
May I please, Lordship, may I just make one last submission? I've been informed that 3 of the parties have already expired and the earlier union, which was there, has been disbanded. So it's no more there. So remand would, Lordship, be a little.
That will be taken care of by them, by the labor court. You see, I'm exercising certiorari jurisdiction. I would have otherwise decided this. But the fact that he did not decide the merits, I can't decide. I'm not sitting in an appellate court. No? So you make that thing, then they will be represented by them because the issue has to be decided. When a reference is being made, it is for them. But the learned labor court may say that there is no issue. Now tomorrow, just for example, the person who had died, his legal representative will have a right on the back wages. On 22nd of June, the registry is directed to forthwith return the records to the learned labor court Dibrugarh so that the proceedings can be initiated, so that the reference proceedings can proceed on the date so fixed herein above. If so necessary, the registry is further directed that, in addition to that, it is also directed that the registry may employ the services of a special messenger for the return of the reports. Next. Sorry, madam. I'm sorry, madam. I could not hear at the F2, madam.
Have to go to F2. I was not present, my lord. That's okay, no problem. Because I F2.
Wait. Let me complete his matter. Where is that Mr. Mention? He'll, otherwise he'll be very sad. Means item 4. Settled.
I'm obliged, my lord, your lordship has recalled.
Ah, yes, we can't help it but to give you indulgence.
Flag R, your lordship will find me up. Mediation.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Mr. So-and-so who appears on behalf of the respondent. The issue involved in the instant proceedings. The petitioner herein have assailed the award dated 2/4/2018 passed by the presiding officer, Labour Court, passed by the Labour Court, Gauhati, Learned Labour Court, Gauhati, in reference case number 5/2006. The record reveals that in pursuance to an order passed by this court on (28/8/2025), the instant proceedings was referred to the special mediation drive for the nation was referred to mediation in pursuance thereto. It has been brought to the attention of this court by the report of the learned mediator that the matter between the petitioner as well as the respondent have been amicably settled, and an agreement has been entered into on 27/3/2026. Taking into account that the said agreement has been held, agreement has been arrived at without any fraud or coercion, comma. The said agreement is duly accepted. The said agreement, this court further observes and directs that the terms of the agreement shall be a part of the instant order. And the parties would be bound by the terms of the agreement. With above the instant proceedings, that's disposed of. The reports.
Right. Alia.
Yes, wind power infra co. What is this?
Yeah. Issue pertains to termination of the LOI. At a later point of time. When
Why the LOI was terminated? Where is the order of termination?
Yes. 371, please.
Page
271 of Bullet.
71.
71.
No. 171.
371.
371. Speaking order.
They passed speaking order.
Yes.
So, let the, your, we have said, this paragraph proceeding on of this section. It is observed,
What was the rate fixed?
the rate fixed was, my rate was found to be L1. First LOI lordship will kindly took up. At page 130,
At page
130.
9 crores 99 lakhs,
Yes.
31,159 and 40 paisa.
Yes. Let me see here.
And,
So this LOI,
where's the tender?
the document was pay.
What?
Children application.
Where's the tender document?
Additional affidavit.
Starts at page 384 of the additional affidavit filed by the petitioner, page number 384.
So the cost is 12 crores 49. You want to do it at 9 crore 99. Now,
They have therefore categorized me that my bill is abnormally low. So they wanted additional performance guarantee besides the contract performance guarantee.
you gave that.
I submitted. Including all other information they asked for, we gave, and then we submitted. At page 395, Lakshmi can be seen.
Yes. Abnormally low bid is one which is the bid price in combination with other. You full note that is the biggest concern to the purpose of identification and that's. Competition and the thing that okay.
Now, therefore, let us categorize me with low.
But, Mr. First tell me why should this court interfere? Arbitration first. 29.
Let the, you see, when the LOI, once more, let you, and I will put. They're having done for all this purpose. Motivation. So, close to the,
Honestly, Mr.
Yeah.
Mahanta, you are now going to submit. Your submission would be, you see, this is at the time of tender evaluation. They having been satisfied, they have issued the LOI. So thereafter, they cannot initiate the process which is given out there at what pay. Before.
yeah,
That is your submission.
the other hand, the LOI, they should be here in this context, to be considered to be LOA, because they have asked me to deposit, else I'll forfeit under their own terms and conditions, I'll forfeit my deposits. Clause 11.
Understood. But why should this court interfere?
No, that, when this exercise is totally arbitrary, they could not have subsequently raised this issue and gone for cancellation without any just ground, without any just reason. And when they have accepted my all security, and I have explained it, they have simply now said that my calculation was wrong. Is flawed. They have already gone through it. And the MD is the chairman of the tender evaluation committee. They have found me LOA and therefore asked for all that. And thereafter they asked me that you deposit, because you are abnormally low bid, you deposit additional bank loan. And they have taken it. That LOI for the moment.
That is understood, but this
And
doesn't,
then
but Mr. Mahanta, they are not satisfying this court as regards the alternative remedy.
alternative remedy.
The question as to whether it is abnormally low, as to whether they have any other things or not, you may be entitled for breach of contract or whatever may be. These are things that are there. Why should this court entertain and the 226?
Government to protect my rights under Article 14.
No,
When the authority has acted in a manner which is arbitrary per se arbitrary, unjust.
It is not an arbitrary, it is not in terms with the, it will be addressed, your submission therefore is, once I have been issued an LOI, you have already decided all this thing. And as such, everything is complete now, you cannot again go back to that.
Yes. But if that is,
These are
oh,
things
what is
that
the
are
purpose of my price bill has been opened? My price bill has been opened, and they, before opening the price bill, they have verified everything required under the terms of the contract, and they were happy that I'm a responsive bidder. I'm a responsive bidder. They opened my price bid ultimately and found that abnormally low, not that low, but extremely low. What they said is some 9 point some percent, some 74,000 difference from the L2. That is the
No,
difference.
no, no, we are not concerned with
I'm
that.
not going with that.
But the fact is, the total contract value was 1249. Will quoted 999.
Yeah, because
It's almost 20% below.
I have certain advantages too. That's why I have explained it to them. They
They
are,
are not satisfied with the explanation.
yeah,
How would, which would be satisfied with your explanation?
no, but they having been satisfied only issued the LOA. LOA was issued after being satisfied. That explanation was given, they found it. Otherwise, they could not have opened my time. That's all. They would have rejected me and that.
You have been issued a letter of intent.
Then, but that is here in this context, it is clause 6 can you see, if I am working. 390. 8, 390 or 6. They ask for an agreement. Here, an agreement is ultimately made.
Successfully shall explain an agreement with the acquisition within 7 days from the issuance of, from the date of issue of the same work order.
Wedding which
LOA shall be issued as cancelled.
cancel. Without further
But
yeah.
Mr. Mohanta, you have been.
Now, NDCL.
Now, there are many judgments of the Supreme Court.
Carrying
Carrying Act.
Yes, yes.
I am carrying it as
Give me one recently.
Southern
the
Coalfields.
Supreme Court just-
Southeastern Coalfield,
No, recently, the new judgment, I think around,
2021.
no, more than that. Anyways, told me that. LOI, I have built it in one judgment.
Malad, let me complete my argument on the LOI. What you will see the,
But Mr. Bhavato, I'm not very sure.
Malad, and you should to place it for your lordship, so that lordship can consider it from all relevant aspects.
Paragraph 22. 2021 906. 22.
How will be that notification of the award? How will it?
That your lordship will find at page number 390. 390 read with clause 15 at 392. Award of clause.
So where's the information?
Yes.
I mean, there are terms for instance, that is information of the award. Correct. Oasis, Oasis case. The item is missing.
That's apart from that.
Now tell me, can you come to clause 8? 8.
Madam.
On clause 7 saying upon issuance of the LOA,
Madam.
within 60 days he has to give the performance guarantee.
Madam.
Isn't it?
Madam.
But if it is a case of abnormally low,
Madam.
then that, and if it is below 20%,
Madam.
that it is an additional security shall be given to the extent of 15% of the contract price.
Madam.
Now tell me here, something is 1.2,
Madam.
in submission of the additional performance security shall constitute sufficient ground to reject the bid. In similar assessment pursuant to clause 1, this is this clause 1, will be made for the next higher direct bidder.
Perhaps it refers to clause 8, subclause 1.
8 1.2.
8, 8, 1 and 8, 2. Yes.
The clause 1
So it says that there will be two conditions. Firstly, if the bid is all right, then he just has to submit the performance guarantee and proceed with the work. If it is an abnormally low bid, then he will be asked for additional guarantee in terms of clause 8. Now, if he does not submit the guarantee, then an assessment will be made for the next highest bidder to determine if his bid is also abnormally low, and then he will be requested to submit the guarantee, and then so on and so forth. Because this is an additional guarantee apart from the original performance bank guarantee.
what is they are referring to
My lord.
8.1 or what? What do you mean by 1.2? And similar assessment pursuant to clause 1 will be made for the next bid. Which clause they referring? Now, you see, even if your judgment, that judgment is looking for, it says that the letter of intent normally is just an expression. And thereupon can also be decided on the basis of the NIT conditions. Now, the NIT does not conceive of a letter of intent.
Does not.
It consists of a letter of acceptance. So my question is, would that amount to issuance of a letter of intent? Would it be a prelude to a letter of acceptance? And thereby asking him to submit the addition they have for consideration of the bid? Because you see, about 1.2 say that if he's not, his bid will be rejected. And it goes to the Yamini, thereby the tender process is still
On.
it is alive.
Precisely.
The evaluation of the tender process is still alive.
In fact, the letter of
Now, if you see the judgment in Oasis case,
I know.
which I think, in the latest judgment, 2025, it is on 24th of November 2025. Here the issue is one. Whether the LOI created enforceable right in favor of the respondent company. This is the specific issue. The jurisprudence on the subject is neither nascent nor unsettled. A canon of decision from this court is also considered. LOI is in the ordinary course of precursor to a contract and not the contract itself. Dresser, Rain versus so and so, these authorities collectively articulate a coherent doctrine. And LOI creates no vested right until it passes the threshold of final and unconditional acceptance. It is but a promise in embryo, capable of maturing into a contract only upon satisfaction of the stipulated precondition or upon the issue of the LOA. Therefore, you see, you have that judgment.
I do.
Where is it?
I do not have.
No, not there. This is your crunch, paragraph 15. That is why you see the LOA.
The interesting phrase, promise in embryo, means not yet delivered.
And thereupon the LOA will be. Therefore, I say, clause 8.1.2.
My lord.
It says, therefore, the bids are still there.
Yes.
When there is an abnormal bid, you are required to pass even additional sum security.
In fact, the LOI which has been issued, the first line of that LOI is very interesting, Your Lordship. It says, the undersigned is
Intending to place an order for execution of the work at your quoted rate against the above referred NIT.
It means that they are contemplating issuance of a separate work order after, if he meets these requirements. And
So that is one. Secondly, then also Mr. Mohanto has a case to the effect to say, okay, LOI has been given. I have satisfied the clause by giving the additional performance security. Why you are not accepting it? On the other hand, I have given the performance security up to 15% of the contract price.
it was rejected on a different ground, Your Lordship, not for submission of the guarantee. There is a requirement under the contract that a successful bidder, apart from being technically and financially qualified, he also has to meet a minimum threshold of a bid capacity for one of the past 5 financial years. The petitioner submitted his documents in a format required under the tender. Along with the document, he was supposed to submit certain additional documents. The document mandates. Those documents were not submitted along with his book. So after, and in fact, before issuance of the LOI also, we requested him to furnish those additional documents to us. Those documents were finally furnished after issuance of this LOI. The committee which was constituted examined those documents, and those documents were found to be unsatisfactory regarding calculation of his bid capacity. It was for failure to meet the minimum bid capacity laid down under the tender that the LOI was finally cancelled.
Then number 15, Roman 3, 1892.
My lord. My lord. The portion in bold, yes.
Let me come on the. So, in terms to make that thing otherwise dismissal. I'm grateful that what they have got to be the core.
Here now, they have not say that my bid is or they cannot act upon my bid feasibility. What they say is that the bid capacity calculation, which I had known, yes, subsequently found that there is no foundation. And they say now that we have failed to give particular explanation. Now, Lordship will take up their repeatability. What are the improvements there? Firstly, Lordship will see that this process, as Lordship has already followed for the Lordship. This process they have already undertaken, and then they open by price.
The pricing has to be open.
Yes, after that will be only when contractor and better bidder is found to be responsive with techno. And there they wanted all these documents.
That doesn't arise because of the fact that do you disclose in your technical bid what is your price? The total is 12 crores 49 lakh. Out of that, you have only disclosed in your financial bid that it is 999. So therefore, the price bid has to be open to know how it is.
No, that is definitely. But once only the bidder who is found to be responsible in technical bid, and there to support their financial position, they are required to submit all the papers,
The bid capacity.
the bid capacity, all the papers pertaining to bid capacity. And see that clause also is there. That clause also 45%. Technical bid, what are the bidder shall have page 380.
He paid 388.
388, five, clause 5 says, is it qualifying the requirement? And they said that to be qualified for the package, bidder must compulsorily meet the following minimum criteria. Technical, a prospective bidder must fulfill the following qualifying requirements. A, and then A, B, the bidder must register themselves as a contractor of the district. B, the bidder must have valid electrical contractors or supervisor's license with the district. Now, C, the bidder must have experience of and is successful.
Now we have to come to 5B. 5A we are not concerned, 5B, mentioned.
IB, yes.
Average age of turnover of the bidder for the last fee for whom the year shall be as per the entry fee. Annual turnover must be certified by a registered chartered accountant. It shall be supported by appropriate audited balance sheet for the last 3 years, along with the income tax return. In case of joint venture, joint venture,
I'm a, they actually, yes, I have a joint group of people.
you are a joint venture.
A group of people.
Once the figure of the average annual turnover for each joint venture shall be added together.
Yeah, I'm applying.
Let us see what is the ground for rejection.
My lord, 5C actually. It is actually 5C here. Bid capacity. 5C. There is a column C, bid capacity just below that. In addition to technical and financial.
It is qualified only their available bid capacity at the time of bidding is more than estimated cost of the project. The available capacity can be calculated as a A, the for a year prescribed for completion of the work into B minus B. Value the existing commitment. Yes. So this is similar to the PWD, what they did.
Yes.
So now what has happened? They don't meet this.
They don't meet C, bid capacity.
No, why do they not think? Where is the calculation?
The calculation that they have provided, your lordship will find at page number 102. 102. This is the affidavit provided by the.
Yes.
If your lordship turns over to page 103,
Yes.
the highest figure according to them in the last 5 financial years was in the year 21-22, an amount of 13 crores, 5 lakhs, 2,000. One. So there, if your lordship comes to the paragraphs below, figures to be mentioned in column A.
No,
shall be
no, no,
supported-
it's 130 crores.
130 crores, I beg your pardon. 130 crores. Figures to be mentioned in column A shall be supported by relevant copies of the work order, stroke letter of award, as well as the corresponding completion certificates issued by the officer not below the rank of CEO,
Yeah.
stroke DGM, stroke superintendent engineer of electrical improvements. So these documents were not provided along with the bill initially.
1 year has been put. Why they have put only 1 year?
That is the requirement of 5C. The highest of clause 5C, the requirement is the highest year amongst the last 5 financial years will be taken into account.
Yeah, 130, 130 crores
130 crores in 21-22.
into Iman into 2 minus 0. So they have no other work.
According to them, this is that year. So documents were initially not provided. So we kept on writing to them to provide these documents. Finally, the documents were provided. The date is 10/2/2026. The
10 to
2020. It is a page number 145.
55.
Yes. Submission of supporting documents against bid capacity calculation.
And when was the LOI issue?
The LOI was issued, Your Lordship, on 5/2/2026.
5 to 26. This is submitted later.
Submitted later.
And please note that above you cannot be, what did they say?
My lord, they had submitted several documents. The dispute arose because if Your Lordship turns over to page number 170,
170.
170, this is a document submitted along with this letter. This is a work order issued by Wind Power Infra Private Limited in favor of Wind Power Infracon LLP. So their their own sister company issued a work order in favor of the partnership firm. Then the completion certificate for this
21.
21. This is for the year
This is for 21, 22.
21, 22. There are other.
This is an existing work.
No, this has been shown to be completed. There is a completion certificate also.
So that was given by their own authority.
So the dispute arose why their APDCL rejected. If Your Lordship turns over to our affidavit in opposition, this work which they have sought to be, they are seeking to show that it has been executed by the LLP. In that contract, to subcontract the work, explicit written permission of the contractor of the employer was necessary. That was one of the conditions. So without taking, and we were the employer in that contract. So without taking our written permission, they could not have subcontracted. This document, Your Lordship, the authority and the evaluating authority in its wisdom did not find it to be satisfactory.
That's the ground main.
That is the ground on which the committee came to a conclusion that this work order which they are relying upon,
The committee observed that these works cannot be considered for the purpose of calculating the parameters of the as the bidder has been shown as a
subcontractor
in the certificate, and no work order is found even after repeated request for submission.
Yeah.
Moreover, the bidder has carried subcontracting without the approval of the employer.
Yes.
As you.
In the earlier contract, where they are shown to be a subcontractor, we were the party which is originally issued the tender. That tender is also part of the record. The clause relating to subcontracting.
That as per volume 1.4. In the execution of the contract shall not be subcontracted without the written permission. On the records available, it is found that no such approval of subcontracting has been according to the bidder. So you mean to say that this particular 107,
My lord,
8783, which has been taken along with updated value of the work of 130 crore,
my lord,
could not have been taken
could not have been taken.
because it was a subcontract work
My lord,
as a working as a subcontractor and without the permission.
yes, my lord.
This is why you have done.
My lord. That is our,
But is it your term that subcontract would not be taken?
my lord, my lord. If Your Lordship turns over the tender from which the word they are relying, if Your Lordship turns over to clause 926. This is a part of my affidavit approach. This is the original tender from which they are claiming the experience.
926, 916 I have.
926.
Yeah.
Yes.
Affidavit in reply. No, those are
My affidavit approach.
very good. Your affidavit starts at
It starts at page number 892.
okay, 926.
My lord.
It's okay. Very good. You have given us some ago. It's okay.
Nine,
Which document? It's a G.
my lord, 926 is a part of,
The chain.
yes, it is Annexure G.
Annexure G.
Annexure G.
Okay, this is a different contract.
My lord, they are the,
I'm not on that. I like to change whether a subcontractor cannot, a subcontract being given
my lord,
cannot be taken into consideration for evaluating the bid.
My
That's
lord.
it.
my lord. Specifically, it is not written in the, it is not a term in the new contract.
And
What the new contract mandates is a submission of a work order and a corresponding completion certificate. Now, if your lordship turns over to that requirement,
so have they given the completion certificate?
it says that the work order and the completion certificate both have to be certified by a officer of the level of a CEO, DGM or subsuperintending engineer.
Where?
It is the requirement of clause annexure 1E, your lordship. If your lordship has, for example, page number 402, annexure 1E, in the format in which this experience criteria is to be submitted.
Page
Page 402. 402.
402.
If your lordship has annexure,
Loan shall be supported by the work orders and UI.
so they have the completion certificate issued by a rank of the officer of the rank of CEO, DTM, but the work order is not. The work order which they have submitted is a work order which they have themselves issued to their sister concern.
But isn't that a work order?
It is not a work order certified by the CEO, DGM, stroke superintending engineer.
Where is the
The
document?
work order document your lordship will find at page number 170.
17. It's for the arbitrator to do, not for me. Anyway. It
This
is
is
given by A.K. Tiwari, General Manager to Wind Power. So what is the petition? Wind Power Infra LLP. Okay. It is given to Infra LLP.
By A.K. Tiwari, General Manager, Wind Power Infra Private Limited.
Okay. Then
This clause was specifically inserted in Annexure 1E because we are aware that a lot of our former bidders come up with these experience certificates where they claim experience on the basis of work formerly awarded by us. To ensure the veracity of those documents, your lordship, this clause was inserted. So
where is the completion certificate?
the completion certificate for this, your lordship will find at 173.
170.
This has been issued by officer of the rank of CEO.
In whose name? 173.
The loan officer has certified.
Yes, this we have certified.
No. This has been worked by, the scope of the work under AR in the above has been executed by MS Windpower as subcontractor in all respect as per the technical specification and supervision of the APDCL.
This completion
So
certificate.
isn't it amount to the APDCL giving a blessing on this certificate?
Under what circumstances this certificate?
I'm not on
Yes.
that. We are not on certificate.
Even I-
Circumstances. Don't come up.
But the requirement of the tender, your lordship, because it has to be strictly construed. The requirement of the tender is both the work order and the completion certificate have to be issued by a certified by a officer, not below the rank of so and so and so.
Work order also.
Yes, that is the requirement of Annexure 1. Figures to be mentioned in column A. This is page number 402.
So you need to say that the work order also has to be certified.
Certain issued by a officer of not below the rank of CEO, DG, and superintendent. That is the requirement.
But that's the reason.
My lord.
If that's the reason.
That
which
is
you
the
have
reason.
advised that. Where's the reason again? I saw it somewhere.
Yes, the reason your lordship will find, it is at page number 371, the speaking order.
No, just now I read it. No,
Yes, sir, the 371.
no, not this one. The other one. There was another reason. Huh?
Yes, there was a committee, the
The
minutes of the committee, your
that
lordship,
is there.
928. It is in my affidavit.
Yeah. Page 911 actually.
Uh,
The committee observed that all these works cannot be considered for the purpose of calculating liability as the bidder has been shown as a subcontractor in the surveyor and no work order is found even after repeated requests for submission. Moreover, the bidder has carried out subcontracting without any approval of them. But this is the such you have the blessing. You cannot have that. The state work mandated as per so and so, so and so. But the fact remains that this is a thing that this work order has also to be certified. And he has not produced that.
he has not produced that book.
So therefore you say that the capacity is not.
Not to our satisfaction, it is not.
But this happened later on.
After issuance of, because, but the chain of communication, your lordship, started prior to issuance of the letter of intent. The first request, your lordship, to submit such documents was in fact made on 2nd of February 2016. Prior to issuance of the letter of intent. So that in fact, the chain of communication is established, but the letter of intent was only a part of the negotiation between the two parties.
What was this document may also kind of see regarding the work order, using work order, whether this condition was incorporated here. But you can see a page.
No, but fact remains that you see, it is an LOI. It is not a finality. So they have they can very well, you cannot say that, or this court cannot say that, okay, why are you again looking into the technical thing, whatever you mean. They have the liberty to that. We can't look into it. But the only thing my question is whether the justification of the bid capacity was not proper or not. This is the question, Mr. Monto. Either you take a dismissal from this court or go to the arbitration tribunal, whichever it is.
No, it does not come only when contract will start. If contract will
No, contract will start immediately. See, kindly see the arbitration clause. In case of any dispute, controversy, or claim arising out of relating to this contract agreement, public agreement, the matter shall be settled immediately between the parties. The matter shall be settled within 30 days. In case of non-receivable response of the notice on the one, then the dispute, controversy, or claim arising out of or relating to this contract of the agreement of breach of the termination or invalidity thereof shall be settled by arbitration in accordance with the contract signed. No, the contract, what is the contract? It is not required for a contract, the agreement. See, you have submitted certain documents. There is a breach to the effect. When they are making a proposal to you, they are giving you a proposal. In pursuance to the proposal, you are giving an offer. And in pursuance to that, they have not accepted, but they have issued a letter of intent. Now they have cancelled them. So under such circumstances, this is a case for arbitration.
But also
There will be in case of any dispute, controversy, or claim arising out of and relating out of or relating to this contract of the agreement, the matter shall be settled in integrity.
Plus in matter of stability. There must be a concluded contract, and here is the conclusion. Say that there is a concluded contract, but then there is a dispute arose. In that case, we have gone to the court. what is bilateral submission mean? The Crown is apparently arbitrary for what they wanted only the certificates in their own terms of right. Nothing more. I submitted all that. Thereafter again, they wrote to me before issuance of the I submitted these documents. Can you see? I initially did draw your lordship attention to page 388. Then again, lordship will see here that clause 5 and coming down that key. The bidder shall submit certificates of satisfactory operation of the works submitted to fulfill as required above and on date of opening of it. I submitted all that on date of opening of it. Then again, experience certificate must be from an officer not below the rank of CEO, EGM, superintendent engineer of electrical utilities. That is what they asked for. And we have given it. And you have not given the work order issued by superintendent. Yeah, it was not there, no certificate. And nonetheless, we gave it. Only certificates, what they say. See,
So you are therefore asking the court now to interpret this particular term. Either it is mentioned in the column A shall be separated by relevant copies of the work order of the LOI as well as corresponding AI issued by officer not below the rank of point. They say that the work order and LOI has to be only issued by these persons,
yes, you say that
not by way of subcontract.
yes, I performed those works, subcontractor, under my main company, that is, uh, wind power, under wind power. But their authority has certified that yes, I have completed those works and they were all happy certified my experience and they found the income I generated from that is shown in my balance sheet. What more they want? They want to show that whether I have capacity to actually work. I have money in my hand. That's true. They are not saying that you do not have experience. I have experience. They are satisfied. I have experience. I have worked. I have performed to their satisfaction. But they say that the income you derive and shown in your balance sheet, that was why we have a subcontract. Is it applicable here? Is it not arbitrary, my lord? I ask my. They never say. I'm grateful not to ask that question. Is there any terms here which say, and I agree, that a subcontractor who worked earlier as a subcontractor, he cannot afford a bill.
No, therefore I'm not agreeing to that.
Yeah.
Whatever may be, that
No,
is
madam,
but the fact is, except then, the particular figures to be mentioned in the column A shall be supported by relevant copies of the work order so and so, issued by the officer not below the year. You say that it is only the completion certificate which has to be issued. And as for them, the work orders also have to be issued. Now, if that is the term of the contract, and it is the understanding of the court is concerned, so can this court now, in view of affronts, go into and deal with that?
Will not definitely go into hunting for those things. Only lordship will see the procedure they have adopted. I'm on that limited jurisdiction. Therefore, conditions of NIT has been fulfilled. Is it their case that you have not fulfilled the condition of NIT? They found me that I have fulfilled.
Okay, Mr. Monto, we have it again on Thursday. Thursday, 10:30. Before we talk on Thursday, because let me have a thought about it. Because I delivered a quote in the program. Only let me think about it only on that aspect. This reason which has been given is on the subcontract. Now, this Oasis, otherwise your letter of intent has no value, I tell you. No, letter of intent, Mr. Monto has no value.
Allow me. Last
I'm
line may have missed it. Can you see the last line of that LOI? In the separate page.
Where?
Last line of the.
Okay. Where's the LOI again?
130 and 131. 131. Having said all that, then in the last line, page 136, 31, it says, kindly treat this as the letter of intent and upon regular acceptance of the date within 7 days from the date of LOI. And the apex court has interpreted that the first circumstance says LOI can be read as an LOA. It has to be seen on the facts and situations of the case.
Where?
That decision is, my lord, and going on. 2006 1 SCC 751 is the refer land trust A.
In,
Single agro.
this has been taken into consideration in Oasis. Oasis is,
Yeah. Well, this is still a good law.
Oasis treated it. No, it's okay, but that has been taken care of and the court has come to a finding to the affair. Here it says, what is the requirement of a LOI is given very clearly out here. So to hold otherwise would be to bind the state in a contract before it has consistent to bound the proposition foreign in both to and fro. So therefore it will be dependent on the NIT conditions. But the fact remains, Mr. Monta, the problem where you are is the NIT does not conceive of an LOI. Problem lies there. NIT does not conceive of an LOI.
Yeah.
Rather, no, it only conceives of a letter of acceptance.
Accepted.
Now,
Therefore-
therefore, I'm saying this paragraph 15 of the judgment in OAC takes care of that. It says these authorities collectively articulate a coherent doctrine. And LOI creates no vested right until it passes the threshold of a final and unconditional acceptance. Now here it says kindly accept. It is but a promise in embryo, capable of maturing into a contract only upon the satisfaction of the stipulated precondition or upon the issuance of an LOA. A bidder's expectation that such contract will follow may be commercially genuine, but it is not a juridical entitlement. To hold otherwise would be bind the state in a contract before it is consciously chosen to be bound, a proposition foreign to both contract law and public ear. Turning that to the LOI before us, it is conditionally beyond the doubt for undertake. It says that it is required the company to undertake so and so, provide live demonstrations when release requirement was framed as a condition precedent and LOI itself that the final award will be issued only after the so and so this release. So whatever may be, the fact remains out here, Mr. Mahanta, there you have a problem. The only thing which this court is going to look into is this, as to whether it is required for you that can this court interpret that the completion certificate shall only be required for a certification by these authorities and not the work orders. Taking into account that because whether in the terms and conditions of the work order, you have a look at it in the NIT, what type of work orders are they asking for? If in those work orders they are not mentioning or qualifying that it has to be by the authority capable of a statutory authority, then can you then ask them, say that it has to be given by the DGM? Look into that aspect.
I only just point out here on the one. That LOI is concepted here. The NIT.
Where?
Where? At 391.
A91?
All the level. Two part law.
Where?
But that's the NIT.
Huh?
391.
Yours?
All the level.
The EMD of the successor will be forfeited on non-acceptance of the letter of intent within the stipulated period mentioned in so and so. On non-acceptance of the letter of intent within the.
mentioned about the war, time limit, everything has been mentioned. And then you accept it, you decide. If you don't do it, you will forfeit. So therefore, my suggestion is that.
But the question is,
In that
see,
context,
where is an LOI concept? LOI is also there. When LOI is there, LOI is there, then LOI is there. LOI has to be a prelude to an LOI.
normally that is the provision embryo, then it would not have gone to that extent. That unless you accept it, that you will forfeit all. Therefore, my approach is that in normal condition, yes, in normal conditions, LOI, therefore only the embryo. But here it is not. And that's why they have put it, that it can be construed as an LOA on this prevailing facts and circumstances of the contract. That's why in paragraph 40 of that division, that there are 200.
But unless you include an LOA, can you be issued can there be an agreement?
Can be.
Huh?
Can be, because
No, it cannot be.
no,
The successful bidder will enter into an agreement with acquisition within 7 days from date of issuance of a detailed work order LOA. So without the issuance of a LOA, you cannot enter into an agreement.
And how that is to be awarded is in clause 15.
work order will mention about the what? Time limit and to go ahead. That's what
No, they have interchangeably word work order bracket LOA.
LOA. That is, all of therefore, all of here. This LOA also have been LOA.
Yeah, there is other aspect of the matter.
Matter having been heard at length is the matter on 7/5/2025, 26, 10:30 AM for final. He came out of past the list to continue. Hey, two whole HCC online today. I have it in my book. Oh. In view of lesser rent where you are referring to, we should therefore go to arbitration. It's an arbitration matter. Yes. No. Go to arbitration. You are referring to the judgment.
And in fact, it's prayer made for specific performance. The section 17 of the, in fact, that is also part of it.
Huh?
Prayer is for specific
And
performance
you
of the.
may you correct your thing with these people, huh? Don't come up with those other numbers. 928 is not there in our pipeline. My file contains other people. Respect of some of the respondents, officers are still in country. There's a matter with the division bench. Oh no, it petition. Now why the matter come up before me? This is for this prosecutor. Yes. Okay. Okay, you have filed affidavit. Oh, well, I could file it. It is not on. I could file it today. It is not on. I am the expert. You have filed it today. You want to file a reply? 14. What about the other? Service has been affected? Well, there is a use of this note, it says there are in respect of so many respondents have been delivered to the respective address. But whether you Someone still, in respect of one respondent, 155 videos come later because the address is insufficient. You do one thing. Yeah. Last time it was said that notice has to be done and all. Mr. Nath, each matter requires an urgent disposal, taking into account we have a big problem on the infrastructure bench as we have taken. This matter requires to be resolved as soon as possible. So, if necessary, if the service is not complete, you take it, say, you take it under you, these people are working. So, check the service because you have to send them somewhere. So, therefore, let it be done to it's so that they don't also have a say out there. What needs to be done. Then the matter will be expedited because here you have worries out there, there is a delay out there, it is affecting those. They are also, these people who have been appointed, they are also in a dilemma out there as to whether they will remain or not. And then you are also going to spend huge amounts on their training, which because I am in the committee of the Judicial Assembly where they have asked you a huge amount for you for this training. So these are therefore, I think the matter requires. So let them file an affidavit to that and affidavit in reply. In the meantime, you provide extra copies of him so that he will take. Now, that is a better way for bringing this matter to a closure. Yes, why are you appealing? And then, oh, fantastic, good. Then he has the lesser trouble of making lesser profit. Representative capacity there before. But then also you never know. Challenge may be made only on the ground that I did not see. Yes, you are paying for who? For whom? How many? Give the number. So they must have contacted you. So therefore you will be knowing the name. So provide the name. Okay. Let's have it on Thursday, Friday. Friday we have it. And that day you get your instruction. Then you will have a letter here for making this copy. Necessarily making copies also, which stage of environment. Yesterday, Mr. Chaudhary, one matter I was hearing only for the purpose that he presented the petition in such a good manner, although he doesn't have it. At the end of the day, I have dismissed it, but the presentation was anyway. Heard Mr. K. Chaudhary, the learned senior counsel, assisted by Ms. Kekulka, appearing on behalf of the petitioner, Mr. Dina, the learned senior government advocate, appears on behalf of the respondent number 127. So, Mr. Dina, the learned senior government advocate, submits that he has already filed an affidavit in opposition to the post. This court have also taken note of, however, the said affidavit in opposition is not on record. The registration do the needful. This court have also taken note of the office note dated 4/5/2026, wherein we see that on behalf of the respondent number 14, 31, and 40, certain the learned counsel have put in their appearance. As regards the respondent numbers 10, 29, 42, 44, 84, 90, 129, 141, 85, so and so, and 250. AD cards have been duly received. In other words, the service is complete as regards the same respondents. However, in respect to the other respondents, in respect to some respondents, namely the respondent numbers 9, 51. Service could not be met on account of insufficient address. However, the respondent number 62, 105, and 190 have received refused insofar as the respondent number 62, 105, and 190, the service is therefore complete. It is also seen that in respect to some respondents, the other respondents, the service is not complete. In the meantime, Mr. T.J. Mohanto, the learned senior counsel, assisted by Mr. P.P. Dutta, appears on behalf of respondent numbers 14 and 31. ये वकालत नामा other counsel, namely, Mr. T. Sinha, appears on behalf of the 14. Mr. Arthur Pujari, the learned counsel, further appears and submits that he has been telephonically instructed to appear for some of the respondents. However, he is yet to assert he would. However, upon filing the power, he would be able to apprise this court. The learned counsel submits that the power will be filed by Thursday, that is on 7/5/2026. Taking into account the above, this court fixes the matter on 8/5/2026. On the same day, Mr. Arbor Pujari, the learned counsel, says applied this court for which respondents you will be appearing, so that effective directions can be passed. As regards service of notice upon the other respondents upon whom service have not yet been effected in terms of the official dated 4/5/2026. List on 8/5/2026. Yes. Right. Where is the settlement order? Settlement order is also. Society has offered to and fro for AI. It has been pointed out there that there is a dispute and the area of operation of the society which going and discuss about in the life of operation of government. And it has been given to Genamari. That's why it has been given. They have been found to be. Yeah, yeah. Then why should we interfere? Ideas that already go. Going. He takes certificate not there. But they have gone for it. That certificate is not required. No. Unless that was notified out there. Site. But it's like clearance. There's the interpretation business. So why? Because the other one is neighborhood. That's the okay. But it's distance. 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 From who filed the earlier petition? There's a retribution file. It was done in terms with the directions passed in deputy number 1441. Yes. Which one does the final direction deputy number? That is like on the 118. Washington final 116 final. Now what is this Goripur property you have filed the earlier petition? So there is a direction to the Deputy Commissioner. Joint Secretary that the passenger certificate issued in the name of the Secretary of the society concerned can be constituted to be issued. But in view of the correctness of the subsequently issued, this also can be taken as part of the material. We direct the Joint Secretary of the Imam the to pass a fresh order. The issue of acceptance of the passenger clearance certificate to the respondent of the case. The fresh order will be passed within the period of 7 days. The written order. After the written order is passed. That is the important. Well, the direction was. We have to use the corrected certificate issued to the respondent may be taken as the appropriate decision in the legal process by the settling authority. We observe as such in view of the fact that the circumstances in which the incorrect certificate was issued by the INA and also the fact that there was no Bapita proceeding pending against them. It would be permissible in the law to which is an exception to law. So thereupon there was a direction passed to respondent number 8. Who is the respondent? Okay.
But against that order which lordship has read, that writ appeal was preferred and that writ appeal has been dismissed. Yes. Please have that page 575.
And you did not raise the other neighborhood issue in the earlier. No, you did not raise that issue in the earlier petition. Only issue was left was the Bakija here. No, there's no, can you see this judgment of here passed by the learned court bench? We have only said about the Bakija. Put up into the order of settlement made in the favor of the respondent is scaled by the wherein the respect of Bakija is provided the Bakija. So when you are raising this, can you keep on raising your point? My rejection, but you have 149 lakh.
Yes.
And where is the jurisdiction?
Yes, page number 575. We have brought it on record by additional affidavit. Please come to page 577. This writ appeal is filed by appellant being agreed by the judgment and order 11/12 passed by the learned single judge in writ petition being WPC, but by the learned single judge by disposing of the writ petition filed by the writ petition has refused to cancel the settlement of number so and so made in favor of respondent number 8 hearing. Then my lord may kindly skip it. Please come to the para 3. Being agreed with the same appellant approached the writ court alleging that writ submitted by
Is the review order, huh?
yes, herein was not liable to be accepted because Pakistan clearance certificate issued in the name of respondent aid society, which was necessary as per the tender terms, had not been furnished by respondent number 8 society along with the said fee. It is submitted that along with it, respondent society submitted Pakistan clearance certificate, which was issued in the name of its secretary, and as per clause 4 of the tender notification, said certificate would not have been considered and only a certificate issued in name of the bidder society would have been taken into consideration. Learned single judge has agreed with the said submission of the writ petitioner and has held the joint secretary to the government of Assam in the fishery illegally treated Pakistan clearance certificate issued in the name of the secretary of the respondent number said society as valid
clearance certificate, and said decision of the joint secretary was contrary to the provision of clause 4 of the charter notification. However, taking into consideration the fact that respondent number 8 society filed a writ petition being so and so, alleging that though the secretary of the respondent number 8 society applied for issuance of Bakizai clearance certificate in the name of the society, but authority concerned erroneously issued the said certificate in the name of the secretary of respondent number 8 society, and therefore the authority concerned be directed to issue a correct Bakizai clearance certificate in the name of the society. The learned single judge has further observed that WBC number came to be disposed of by this court by order dated 4/11/22, directing Deputy Commissioner Dubey to issue a Bakizai clearance certificate in the name of respondent number 8 society. It is further observed that pursuant to the said order dated 4/11/22, passed in WPC number so and so, a Bakizai clearance certificate issued in the name of the respondent number 8 society, and as such, although the reasoning of the joint secretary whereby the fishery in question was settled in favor of respondent number 8 society is contrary to the provisions of clause 4 of the tender notification, but since subsequently a corrected certificate was issued in favor of respondent number 8 society, pursuant to the direction of this court, the said decision of joint secretary in the fishery department is not liable to be corrected for the respondent. Yes.
What I understand it.
Yes.
Yes, already held that the certificate is including only. Correctly. The society has been correctly issued and can be taken into consideration for the tender.
In substance.
However, in doing so, some justification was given by the joint secretary, and except the joint secretary was asked to correct in the. In fact, that is
Seems I have applied.
and therefore, this is what because there was a direction out there in earlier case, 1441, where we go to specific direction to the effect that you have to give in the society a certificate for the death of the name.
Yes. And my lord, my bid is 1 crore 90 lakhs, his bid is 1 crore 9,000. And my lord, kindly have a look at the last parameter, page 579. Having heard the landed counsel appearing for the parties, and after going through the materials evaluation record, particularly taking into consideration the fact that Bakizai claims had been issued in the name of respondent society, pursuant to the direction given by this court of influence. So we do not find any illegality in the conclusion arrived at by the landed judge in the judgment. It is also to be noted that applicant was one of the respondent in WPC number so and so, but he did not challenge the order dated 4/11/22 passed in the said writ petition. And on this ground also, we do not find any case for interference in this reading.
Because this is the order passed whereby there was a direction to a press certificate. And the other ground of neighborhood, we cannot.
Those were can be taken again and again and again.
Every time.
Yes. In fact, these were not taken, Miller. That's why.
That might not that particular not an opportunity. It's not a bad document will show that if you think might be out of operation.
No, there's an appeal pending in that regard. That is what they say. What has happened to the appeal?
But in fact, the Indian order says that it might not be the details from the
Indian order says that there is an appeal pending.
that has been
The matter is now pending before the Register of Property Society and appeal.
Register of Property.
The entry of the above the society will not have the jurisdiction because there is no stay to that order. So therefore, these are things which will be found out. But what has happened to this appeal?
But again, the appeal has been disposed of, it has gone against me, and it's still pending. Litigation is pending, WPC.
But anyway, so therefore, we are not going to disturb with them. Let's see your petition, what is your prayer? Because whatever they be, the Fishery say would not be whether the report of the deputy commissioner and whether representing the name of the company.
Assistant Secretary, Fishery.
1511. And what is 1710 you are telling me? Huh? Earlier with partial modification of yeah. So that is it. Joint secretary, then the third player is letter report of involvement of the deputy commissioner and further recommending the name of ER consequences. Speaking order dated 14/9 on the detailed brief. Now, whether the speaking order have not merged with the order of 1511? Yes, it had nothing. Who dated also the schedule of the president will bring. So that is not an issue before this court as regards that whether your thing is, we keep this thing open. That as to whether as regards your neighborhood will be subject to the outcome of the proceedings which are there pursuant to the order of confederation.
Well, can I make a suggestion? There are not only 1, 3, 4 petitions. Only point was this Bakizai. Now today he cannot take this point, my lord. He is barred by constructive range litigata. How can he raise an issue every time he feels like, my lord? These are all gone. That is about issue so much issue fresh. That is why I was trying to find a read the particular order of the says, but I cannot pass a confirmation order. It has to be a fresh order. If it is ever a fresh, but the certificate, then on the date of the tender, they do not have the order of the certificate. That point is
But the fact remains that judgment which has been passed in the case of
WPC 7056, page 194.
no. The judgment in the case of 11, in the case of
6885.
that issue what you are urging has already been decided and approved in appeal. So therefore, now can you raise that issue, Mr. Chaudhary?
Moment that was issued, the certificate that is the fresh certificate, not a continuation, and why it is not a.
No, you are saying about that the Bakizai notice, Bakizai certificate. You are saying that this Bakizai certificate, which was issued on the date on which the petitioner submitted the tender, was an invalid document, and therefore this court should interfere. Now, but the fact remains that the judgment of this court in the
There are
2020.
two orders. Prior to that also there is
No,
one.
no, 11/11/2022 in
Yes.
685 creates an obstacle to you, and this has been upheld in the
And
division
this attained
bench.
finally, no, that order has attained finally, that is what division bench said.
That is what I'm saying.
Then after the order, then the certificate issued, has been made clear that this is a fresh.
Understood. But this is an issue which has already been, you see, that is why I'm saying what the learned reported bench say. Yeah. Finally come to page 205.
Yes.
Categorically say, in between then on the first paragraph where the Bakizai clearance certificate was applied for, there was no Bakizai proceedings pending against their. We are of the view that the corrected certificate issued to the respondent may be taken as the appropriate material in the tender process by the city. We observe as such in view of the fact that the circumstance in which the incorrect certificate was issued and also the fact that relevant time of when the application was made, there was no Bakizai proceeding to take the result. It would be permissible under law to take into consideration the correct area for the tender process. After these observations, how do you raise that issue? This should have been challenged in appeal, that this is the point out there. And therefore, the appellate court says that you should have challenged the order passed in 1441, wherein there was a direction for issuance of the Bakizai proceeding, the certificate.
In fact, my lord, appeal was against this order.
Understood? That
Yes,
is why I'm
yes. This has been dismissed. Now, my lord, sovereign jurisdiction of my in this contract, that,
that will be subject to the petition.
and the society of 1942, my lord, and it is an area of operation, research, my lord, now.
But what the observations made in so and so will be subject to the outcome of your petition and petition. Or you may very well say that, or I think, when I say that these observations shall not impact you as regards It's then subject to the outcome.
In fact, my lord, the petition which is pending, that is not against settlement order. That is against the order of the Register of Cooperative Societies, which has said something regarding the area of operation and,
So therefore, these observations which have been made shall be subject to outcome, but the question of challenging on the question of Bhakti certificate was not there, does not mean that.
but after this series of orders who say that the cause of action still survive.
Why not the that I was my thing, but I consider because it's not documents that
But that is not the issue involved. What you are referring to, no, you are referring to not on the basis of that. You are in fact taking against the settlement of him.
both mother that I have been handling valid and you have
Why did you then seek for a declaration in your petition that I am a valid so and so, I have a neighborhood? You have to ask it. You cannot ask like this, that this order is bad, that order. They say that there is an order passed by the register of the cooperative society or at that point of time by some assistant or joint register of cooperative society saying that that particular village is outside the parameters and next such you don't have anybody. Isn't it? So therefore, you have challenged that order before the register. At that point of time, the register decree was pending. So they say that as on date, there's nothing, no stay to the effect. So if yes is concerned, it has been done rightly. And this board under 226 is not going to look into those aspects. They should be done. So I think we should go with Mr. President. Wait, I'm passing the order in your presence. Mr. M.K. Chaudhary, the name is Senior Counsel at this by students who are appearing on behalf of the petitioner. So, Kelly, the capable appears on behalf of the respondent number, the knowledge initiative. Government advocate appears on senior government advocate appears on behalf of the respondent. Will be 1, 2, and 3, 5, and 5, 5, 6, 5, 6, 7. Person who is appearing for maximum respondent is not saying about 10 minutes. Mr. C. Gordo appears for respondent number 4. Mr. K. Requested by Mr. Gustav appears for the respondent number 8. The present petition has been filed by the petitioner. Challenging various reports as well as orders passed which led to the culmination of which led to the order dated 15/11/2022. And further seeking a direction that the number 1/87 Darnad Brahmaputra Part 1 and Satpuri Noti Fishery is settled with the petitioner for a period of 7 years, as the petitioner was the valid highest bidder. At the outset, it is very pertinent to take note of that the impugned order dated 17/10/2022, the letter of the report dated 29/9/2020, impugned order dated 17/10/2022, passed by the respondent number 3, the letter dated letter of the report number so and so PRF.5/2020/441-42 dated 29/9/2020 by the Deputy Commissioner Dhubri. The speaking order number DRF 5/020 dated 14/9/2020 of the additional Deputy Commissioner Dhubri. The report number GRP bracket S/3/2019/339 dated 28/8/2020 have merged with the interim order dated 15/11/2022. Under such circumstances, this court finds it pertinent, finds it relevant. Under such circumstances, the issue involved in the present proceeding is as to whether this court is required to interfere with the interim order dated 15/12/11/2022, passed by the respondent number 2. The records reveal that a notice inviting tender was issued on, what is the date?
Page 57, 2020.
On 27/2/2020 for settlement of group number 1/87 Darnad Brahmaputra Part 1 and Sapakuri Modi Fishery. Hereinafter referred to as the fishery in question. For the period from 4/3/2013 to 3/3/2020. For the period from 2019-20 to 2025-26. The said notice inviting tender stipulated various terms and conditions, including the necessity of a Pakistan clearing certificate to be obtained from the concerned office of the Deputy Commissioner, distinctly in the name of the society, or what is that book?
Their society.
What is the translation at page 58 or
The particular Russian finds that process.
Rotor number. Rotor means
That
lot, huh? Or self. Please, they have put root, or self-help group. Self-help. The records further reveal that there have been various litigations as regards the settlement to be made, as regards the settlement in respect to the fishery in question. Pursuant to various orders passed by the learned coordinate benches as well as the learned division bench of the court, an order was passed on 17/10/2022, whereby The respondent society was respondent number 8 society was offered the fishery in question for settlement at rupees 1 crore 90 lakhs 5,000 for 7 years at rupees 27,15,000 per annum. Pursuant to the said order passed by the Joint Secretary to the Government of Assam, Fishery Department, a writ petition was filed by the petitioner, which was registered and numbered as WPC number 6885 of 2012. Challenging the settlements so made in favor of the respondent number 8 by the order dated 17/10/2022. It is further relevant to take note of that another writ petition was filed by the respondent number 8 before this court, wherein the petitioner herein was the respondent number 3, wherein was the petitioner. The petitioner herein was the respondent number 3 in the said writ petition. The said writ petition was registered and numbered as WPC number 7056 of 2022. The case of the respondent number 8 in the said writ petition appears to be on account of the writ petition filed by the writ petitioner challenging the order dated 17/10/2022. That is WPC number 6885 of 2022. It was the case of the respondent number 8 in WPC number so and so 705 that the certificate which was issued to the respondent number 8, but the Bakizai certificate dated, which was issued dated 12/3/2020 ought to have been issued in the name of the respondent number 8 society, but the office of the Deputy Commissioner Dhubri have issued in favor of the secretary of the respondent number 8 society. The learned coordinate bench of the score by an order dated 4/11/2022, passing the WPC number 7056 of 2022, disposed of the said with petition. Thereby holding that the certificate dated 12/3/2020 to be untenable in law, and the Deputy Commissioner Dhubri was directed to give due consideration to the application dated 2/3/2020 issued by the Secretary of the Respondent number 8 Society and pass a fresh order on the claim of the Bakizar certificate in the name of the society. This, the court then bench further directed that the certificate in the correct name, manner as per law be issued within 3 days from the receipt of the certified copy of the order.
This order is again finally been word.
Paragraph number 5 to 9 of the order dated 4/11/2022 being relevant is reproduced hereunder. Pursuant thereto, the Deputy Commissioner Dhubri in pursuant thereto, the Deputy Commissioner Dhubri passed an order on 9/11/2022 thereby directing the e-governance authority to issue the Bakizai certificate afresh, forthwith in the name of the respondent number 8, represented by its secretary, in compliance with the order dated 4/11/2022, passed in WPC number 7056 of 2022. Accordingly, on 10/11/2022, a Bakizai clearance certificate was issued. The records further reveal that on 11/11/2022, the writ petition which was filed by the writ petitioner herein being deputation number 6/885 of 2022, which was put to challenge, whereby the order dated 17/10/2022 was put to challenge, was taken up for hearing. And the respondent number 8, who was the respondent number 8 hearing, who was also a party in the same proceeding, placed the certificate dated 10/11/2022, the fresh Bakizai clearance certificate dated 10/11/2022, before the learned court bench of this court. The learned court bench of this court, by an order dated 11/11/2022, disposed of the said petition. Thereby holding inter alia that the certificate dated 10/11/2022 can be taken into consideration for the purpose of the tender process. And further held that the earlier incorrect certificate to be in the nature of curable defect, which is an acceptable proposition of law in a tender process. The learned court bench further observed that under such circumstances, there was a necessity on the part of the Joint Secretary to the Government of Assam in the Fishery Department to pass a fresh order on the issuance of the acceptance of the corrected Bakizai clearance certificate. And there was a further direction that the said order be passed within a period of 7 days from the date a certified copy of the said order was placed before the respondent number 3 was served. Was served. Paragraph number 4, 5, 6, 7, 8. Paragraph number 6, 5 to 8 of the said order being relevant is reproduced hereinunder. This court, before further proceeding with the narration of the facts, finds it pertinent to observe that by the said order, above quoted order, the learned coordinate bench of this court had clearly observed that the certificate which was issued in the favor of the issued in the name of the secretary of the respondent number 8, dated 12/3/2020, was a mistake committed by the authorities concerned. And therefore, the respondent authorities now, and therefore, the corrected certificate dated 10/11/2022 could be taken into consideration for the purpose of the tender process. The record further reveals that in pursuance to the order passed by this court, dated 11/11/2022, passed in deputation number 685 of 2022. The impugned order was passed on 15/11/2022, holding into alia that the petitioner herein was not qualified, taking into account that the petitioner would not fall within the neighborhood and would also have a would also and also the distance certificate would not be taken into consideration. The reason assigned therein is on account of a proceedings being pending before the Register of Cooperative Society against an order of ARCS Hubli White dated 7/7/2020, wherein it was held that the petitioner society did not have any jurisdiction over the village Madaikali, which is included in the area of operation of Geramari GPMSS Limited under the local name Askari Andi bracket Bagurpara bracket close and Askari Andi Sikasipara at the time of registration in the year 1982. It was also, in addition to that, it was also a subject matter of challenge before the Register of Cooperative Society that the village Madaikali, in respect of Boripur of the petitioner society, and that the list of members drawn from the village Madaikali in respect of the petitioner society, out of the total 75 members, is not valid, which is now under the jurisdiction of the respondent number 8 society It is under such circumstances the petitioner's bid was rejected. The commissioner and secretary to the government of Assam Fishery Department further, taking into account the order passed by the learned coordinate bench dated 11/11/2022 in WPC number so and so, further observed, further took into note the Bakizat certificate, the fresh Bakizat certificate, and thereby held that the respondent number 8 bid was a valid bid and awarded the settlement at rupees 1 crore 90 lakhs, 5,000 for 7 years in continuation of it is under such circumstances the order dated 15/11/2022 have been challenged before this court. Before adjudicating the dispute involved in respect to the challenge dated 15/11/2022, it is apposite herein to mention another subsequent event which took place pursuant to the filing of the present petition. The order dated 11/11/2022 passed in WPC number 6885/2022, whereby there was a specific challenge to the order dated 17/10/2022. The order dated passed in so and so was put to challenge before the learned division bench of this court in writ appeal number 361/2022. The same writ appeal was dismissed by the judgment and order dated 19/9/2024. Finding no infirmity in the order passed by the learned ordinate bench dated 11/11/2022, and further for the reason that there was no challenge to the order dated 4/11/2022 in WPC number 7056/2022. Paragraph number 4, 5, and 6 of the order dated of the judgment and order dated 19/9/2024 passed in writ appeal number so and so being relevant is reproduced herein under. In the backdrop of the above, the learned, let this court take note of the submissions made by the learned counsels appearing on behalf of the parties. Mr. M.K. Chaudhary, the learned counsel appearing on behalf of the petitioner, submit that the certificate which was issued, the certificate with which the petitioner had, the respondent number 8 had submitted the bid, was an invalid certificate. And the fresh certificate dated 10/11/2022 would not have been taken into consideration for granting the settlement in favor of the respondent number 8. Inasmuch as the fresh certificate came into existence more than 2 years after the had come into existence much later. In addition to that, the learned senior counsel have also submitted that the neighborhood certificate, the neighborhood certificate, it's also known as the neighborhood.
They say, they specifically put to challenge the distance certificate. They have not brought in the issue of neighborhood.
Further to that, it has been submitted by the learned senior counsel that the distance certificate which was issued in favor of the respondent number 8 was not cancelled was cancelled on 23rd of June 2020. 23rd of June 2020. And as such, on the basis of the state certificate, the respondent number 8 was not eligible to be granted the settlement. Mr. Kenji, the senior counsel appearing on behalf of the respondent number 8, on the other hand, submitted that the issue as regards the distance certificate cannot be raised in the instant proceedings, inasmuch as the principles of constructive adjudicator, more particularly explanation 4 to section 11 of the Code of Civil Procedure, would stop the petitioner from raising such issue. The learned counsel in that regard referred to the judgment of the Supreme Court in so-and-so versus so-and-so AIA 1986. Whereby the Supreme Court categorically observed that the principles of constructive adjudicator are applicable in writ proceedings. In addition to that, the learned senior counsel further submitted that the issue as regards the Bakite proceeding, as regards the Bakite certificate, cannot also be raised by the petitioner herein on the ground that the learned coordinate bench, on the ground that in WPC number 685 of 2022, in the judgment and order dated 11/11/2022, passed in WPC number 685 of 2022, the learned coordinate bench of this court had categorically held that the said corrected certificate could be taken for the purpose of the tender process. And this finding have not been interfered with by the learned division bench in a challenge made by the petitioner in writ appeal number so-and-so. This court have duly heard the learned counsels appearing on behalf of the parties and have also perused the materials on record. Let this court first take up the issue as to whether the petitioner can raise the issue pertaining to the distance certificate having been cancelled on 28/3/2020. In the present proceedings. It is relevant to take note of that in the earlier round of litigation, which the petitioner filed being the petition number 685 of 2022, the petitioner did not raise the said issue and did not raise the issue as regards the cancellation of the distance certificate. On the other hand, the distance certificate. More so, when the said petition was filed after the cancellation of the distance certificate. In this regard, this court finds it convenient to take note of explanation. Four to section 11 of the Code of Civil Procedure, which is the principle of constructive adjudicator. It stipulates that any matter which might and ought to have been made ground of defense or attack in such form or suit shall be deemed to have been a matter directly and substantially in issue in such suit. This court also finds it relevant to take note of explanation 5 to section 11, which stipulates that any relief claimed in the claim which is not expressly we have been made down the This, it is the opinion of the court that the issue of the distance certificate, if not taken at the time, having not been taken at the time of filing of the petition, when there is a challenge to the order dated 17/10/2020, 22. The said cannot be raised in as much as the said aspect is barred by the principles of constructive res judicata. In this regard, this court finds it relevant to take note of the judgment of the Supreme Court in so and so versus so and so. The relevant portion is quoted here in under. Under such circumstances, the first contention so raised by the petitioner stands rejected. As regards the second contention, as to whether the petitioner would be, whether the fresh certificate dated 10/11/2022, hence that could have been taken in the tender process, in the tender process, pertaining to the settlement of the fishery in question. It is the opinion of this court that the same aspect have already been settled by the learned coordinate bench in the judgment, in the order dated 11/11/2022, passed in WPC number 6885 of 2022, whereby the learned coordinate bench had categorically held that the fresh certificate, said Bakiza certificate, was could be taken for the purpose of the tender process, inasmuch as it was a curable defect. This aspect, it is also pertinent to mention that though there is a challenge to the same judgment order dated 11/11/2022, passed in WPC number 6885 of 2022 in writ appeal number so and so, the writ appellate court by the judgment and order dated 19/4/2024 have rejected the said appeal. Consequently, it is the opinion of this court that the petitioner herein cannot raise the said issue in the present proceedings. Accordingly, this court does not find any merit in the instrument petition, for which the petition stands dismissed. Before parting with the record, this court also finds it very pertinent to take note of a submission made by Mr. M.K. Chaudhary, the learned senior counsel, pertaining to the observations made as in respect to the petitioner society in the impugned order dated 15/11/2022. The learned counsel submits that though the appeal which was filed by the petitioner before the register of the cooperative society against the order of the ARCS decree was rejected, a writ petition thereagainst have been filed, which have been registered and numbered as WPC number. This court observes that the said observations that the observations so made in the impugned order dated 15/11/2022 as regards the petitioner, as regards the neighborhood, distance, as well as the members of the petitioner society shall be subject to the outcome of the petition. Any more matter? Yes. Item number 5. The matter today won't take much time. The matter where a reference was answered and absolutely ignored, isn't it, given by the issue was 19. Nothing but
the case for there is no pending matter. There is elaborate discussion of evidence, everything, pleading, argument, everything, evidence. So my lord may have a look at page 24. Page 24 is the terms of reference schedule.
Now, where is the order?
It starts from page 23. The reference is page 24. The schedule issues that whether the management of leopard cutter tea estate is justified in denying employment to the sons and daughters of retired staff employees, which has been long-standing existing benefit.
Who is this officer? Because you see, when I was a lawyer, I got similar order one matter thing. Because, supposed to remember, there was one matter where I yes, there was not a single whisper of any reason. Just after recording everything, to pass the order to the effect.
Now, my lord, in that case, here it is worse. Page 68, I think. Last paragraph. This is the
I
issue.
carefully shifted the.
I have paragraph 37. I have carefully shifted the evidence on record and considering the submission of the learned representatives of both the sides, keeping in view of all the facts and circumstances of the case, I am of opinion that management policy can be changed from time to time, but there should be consensus between the management and the union. Actually, the issue number 1 is partly decided in favor of the union and partly in favor of the
And what was the reference?
at page 24.
Whether the way denying the. He is not answered.
Nothing, my lord. Which part, even my lord, which part is in favor of the management and which part? Another aspect, my lord.
No more. What do you mean?
No. Since your lordship is, I spoke to your lordship is demanding the matter. Why I am saying that the validity of the reference was vague, but that was also not even. So,
No, you go and fight out.
my lord, while answering the reference, that
What should
aspect,
I do?
no, that aspect.
I'm not going to.
Elaborate discussion of witnesses, the type of thing, two of us. Getting from the management,
No, he has to meet. He has to make the reference, answer the reference.
yes, ma'am.
I was the argument time for the seat and then the council is hearing on behalf of the petitioner. Which A. Richard did along with the council. Respondent. The present with proceedings have been filed challenging that award dated 18/6/2018 passed in reference case number 3 of 2017, whereby the learned Liverpool Sam at Dibuga had disposed of the reference by holding inter alia by holding inter alia by holding that the issue is partly decided in favor of the union and partly against the management. In fact, that line is also partly decided in favor of the union. Very happy gone in favor. And partly against the management, how to get our going to approve the union. The record reveals that where the reference? Reference is where? Before. You can't pass this one. The records reveal that a notification was issued by the government of Assam under Section 10 of the Industrial Disputes Act 1947, dated 18/3/2017, by making the following reference. whether the management of Lepetkat of the state is justified in denying the employment facility to sons of the daughters of retired staff employees, which have been the long-standing existing benefit from us, by unilaterally raising the by, by unilaterally raising the level of educational qualification of the candidates. This would have been perused the award dated 18/6/2018, and it shocks and surprises this court to take note of that the London Labour Court, after recording the pleadings as well as the evidence shown, argument also, yes, because that argument, after recording the pleadings, the evidence adduced by the party as well as the arguments, up to paragraph number 36 of the award, pass the following award at paragraph 37 and 38, which is reproduced here in under 738. The above, the manner in which the London Labour Court have decided the said reference is not only perfunctory, but also goes against the well-settled principles of judicial, well-settled principles, inasmuch as it does not contain any reasons, and not to speak about that also, there is no decision on the reference made by the government by the notification dated so and so. Consequently, it is the opinion of the court that the impugned award is required to be set aside and appropriate directions be issued to the learned labor court, Dismissal, to decide the reference case number 3/2017 on the basis of the evidence by giving due reasons and answering the reference. Accordingly, the instant petition stands disposed of with the following observations and directions. The impugned award dated 18/6/2018, passed in reference case number 3/2017, is set aside and quashed. Number two, the learned labor court, the learned labor court, Dismissal, is directed to decide the reference by answering the reference by answering the terms of reference as notified in the notification dated 18/3/2017. It has been submitted at the bar by the learned counsels appearing on behalf of the parties that there would be no necessity of adducing any evidence. However, taking into account that it will be a fresh presiding officer who will be deciding, this court directs both the parties to appear before the learned labor court, Dismissal, on 22nd of June 2026 to the learned labor court, upon hearing the parties, shall decide the reference as directly within the period, preferably within a period, preferably within 2 months from the date of appearance.